Mangu tugenda kuba tutandika. Tuli mu court, tuli ku anti court martial emakindye. Tuli court martial emakindye. Zure saundi mumpulira bulungi. Sharinga. Tambuza video sharinga kooti egenda kuba ng'etandiko tutuusewo mu budde. Tutuusewo mu budde. Tambuza video sharinga. Era n'amateeka bakatuuka era nga bw'obalaba. Bakatuuka bannabyabufuzi baabo bakatuuka. So tuba tugenda kuba tutandika. Ono Extreme Media is liking the video. Extreme Media is
locally justice. And clearly, for today, you have seen what is happening at the moment. Most of our activists, those that came walking, have not been allowed access, and that the deployment is solid. It starts almost 3 kilometers away from the border. So you don't expect fairness, you don't expect justice, but you expect a repeat of what happened in Council. But that said, we are not going to be intimidated, we are not going to give up, we shall come here and fight, we shall come here and fight until the democracy
Any updates on council keys?
Well, I visited Council Aaron Wednesday, just a day after he was evicted.
Yes.
And of course it was painful. Aaron Atta personally was a friend. It was painful seeing what he had subjected him to. And he was in a lot of pain. First and foremost, he was limping. His ears were swollen and he had scars all over his body. He also confessed to me that most of the severe torture was in the ribs. But also what scared me the most was that when he breathed, his air smelled blood. And for me, most likely he suffered internal bleeding. So Aaron is not supposed to be in Italy at a maximum prison. Aaron is supposed to be at a well-equipped hospital receiving treatment. I gave a call to the president and the society, and one of the things they need to consider is ensure that Aaron gets.
Thank you very much.
Tuwayo mu Luganda. Lebitalo lino other than usual brutality, arrest. Even I came from how long that I can be arrested from here, because I will be sentenced to a year, more than a year. So I'm ready for anything. It's not expecting justice, there's no justice. So we just expect the worst. But we are ready for anything. We are ready to take it. We have listed he's in plea, he has not had medication yet, and he was charged illegally and he's protesting. So he already has instructions to his lawyers, and they are filing some petitions against his position. And we expect any time the High Court, the Constitutional Court will pass this position. All right, guys. Subscribe, ngashare tutandike
Security enough when they responded to proceed that they carry. On the other hand, this is a podcast because I don't see this Starling case basically to answer. If one has not jurisdiction to arrest the person whenever he was arrested in Kenya, what can be convinced that the attackers did not have jurisdiction? The case should collapse and resident should be an innocent person.
Last time we saw Council Kiza being rooted and arrested. Do you have any updates on the Council Kiza? Have you tried to reach him? Have you heard from him?
Yeah, we have heard that the lawyers have visited him from wherever he is. I think what is that place? Italia. But every Kiza's case is very simple. I think he has gone to the Constitutional Court to seek an interpretation as to whether the military court has the powers to sentence him without being heard, contrary to Article 44 and Article 28 of the Constitution.
Thank you very much.
And once court determines that the military court do not have powers to sentence him, the standing case will be corrupt and the punishment given to him will equally corrupt.
Thank you very much, Mr. I'm one of your voters.
Nze njagalako mu Luganda katono nnyo kigenda mu maaso wano eno kimusuubira.
Ekikulu weewaawo tutawaliriza nnyo nga tujja mu kkooti kubeerawo nga musango gwozebwa. Tiwali musango mu mateeka gusitaaninga ku Dr. Kizza Besigye. Yakwatibwa nga bamujja e Kenya. Bwe baba nga bamukwata bannayuganda ate nga bamuwamba e Kenya tibalina jurisdiction ebakkiriza kumuvunaana oba kumukwata emisango gyaddiza ebweru bwegiba nga weekiri. Ekyo nno kintu kikulu nnyo. Singa kooti ematizibwa nti tiyalina abamukwata tibalina buyinza sinza ku mateeka ga Uganda emisango gy'okukomaawo. Naye ffe abatulizinga ebyobufuzi ate nga tuli bannabyabufuzi twebunya nnyo gavumenti eno okubonyabonya Dr. Kizza Besigye, kubanga Dr. Kizza Besigye kiri ku rekodi tiyawangula okulonda emirundi ebiri. Kigambibwa nti mu 2006 akalulu kaali kakuddibwamu, ate nekigambibwa nti mu 2016 yali afuna 52% era yali agenda okubeera pulezidenti wa Uganda. Ebyo byonna obibalirira nesitwako gyatadde okulwanira eddembe ly'obuntu n'ogenda mu maaso ng'omubonyabonya, kubanga tugamba nti olutalo lwajja erweru okutununula lukola kusinze era lutuuse okukoma abalala bagende mu lutalo olulala okujja mu buyinza.
Kiki ky'osuubira olunaku olwaleero?
Kyensuubira olunaku olwaleero zaidi lunaana Dr. Kizza yandibadde ready kuba ku kyeyogera kubanga ddala bali omusango gwonna.
Era abyogera dda.
Kubanga mpulira mbu baagala kwongera ku kyaji ezirala. Zino ziganye okusitaaninga. Neziba nga ziganye okusitaaninga okusinza ku Constitution ya Uganda after sort decrease kubanga tulina musango gw'olwama nga ate oyagala kwongezaako bibaamu nansa. Naye ng'ekikulu kya byonna kyendowooza nga kikikulu ddala presence ya Martha Karua ensanyudde nnyo. Kuyitibwa ng'omusango relying basically on international law. And this is one of the most experienced lawyers to interpret the keynote aspects of international law. Era tutunuulidde nga tulindirira kulaba nti omusango gugenda maaso okozebwa. Karua honorable mukwano gwange mubula basinkanako Cape Town, South Africa, era y'omu kubampa kunonda ku kifo ekyobwa vice president wa Global International ekibiina ky'aba MPs abalwanyi obutonde bw'ensi.
Okay, kati olaba nti fine is an international lawyer naye nothing has been done. Wasi gwe mulundi si lwe lusoose okuba nti nazze. Is that international face?
Abantu bangi batunuulidde Uganda. Batunuulidde Uganda nga yetegekera okulonda okutali wala nnyo ate ng'etandikiddewo buutikira eddembe ly'obwe n'olwekyo okusirika tekitegeeza nti tewali kipulaning ekipulaning bwawe kiri both nationally through the court system and international.
Yes, ku nsonga y'okwa Aaron Kiza bwe bakutte ensonga eyo gyogerako kimu n'amateeka awo.
Dr. Honorable Aaron Kiza amateeka munna bamukwatidde ensonga yonna erisaawo kubanga yagambye nti ndyomu ku balooyazi abazze okukuloyeza Dr. Kiza Besigye njagala kuyingira wano mugamba nti tojja kuyingira n'aleekaanira waggulu okuleekaanira waggulu tikimwongezaako musango n'olwekyo nsubidde nti through the constitutional court tujja gisaba oba ekole interpretation oba ddala court martial yalina obuyinza okusalira Kiza omusango nga
kale
which contradicts article 44 article 28 of the constitution.
Kale eyanza bannange tukyali ku kooti naye nga bwala abantu batandise okubanga tuli ku kooti era balooya banyumirizibwa abampi n'abawanvu olwaleero oba ntwaye Baba, you
kirala tiisatiisa bannamateeka banaffe kize bakirabikako lwe tujja wano naye ffe tetujja kutibaffe tujja kukola nga tulinze kooti bayisome omusango gwaffe tuyingire clearance leero erina engeri gyeyeyongeddemu naye eyo message egenda ku muntu nti ne bwoba ogezaako kwakisesinga court martial olina emitendera gyolina okuyitamu abamu bakoowa ne baddayo nga tebatuuse ne kukooti kitukosa nga bannamateeka naye ffe abaliwo tujja kukola kitusobola ate kukikirira bannaffe Dr. Kiza Besigye
Council tubulirako ku mbeera ya mukwano gwe gyalimu kubanga we know it's your tight friend and it's your workmate. Yes, tell us about the situation. How is Uncle Aaron?
Aaron ye mugumu olwokuba bamukuba bye bamukuba ng'engeri abiraba nga bigenda mu maaso mu kooti naye ekyesanya ekiriwo kisobola okukumirako kati nti bagezezaako okumuwa obujjanjabi mukumira gyali era ali mu kusikonde olunaku olwajjo we twamulabye yaweereza obupaka eri n'agamba nti abali eyo buli omu alina okuguma Aaron ali mukomera olw'okuba yavaayo okulwanira ebitali yavaayo okukola omulimu gwe nga munnamateeka yavaayo okujja mu kooti martial okubalaka nti amateeka gafuga eggwanga lye CUPDF Act ne regulation zasomera naye kifuga eggwanga lino constitution yaffe yessemateeka waffe era kye balina okuyiga okusoma ensonga lwaki ali mukomera n'okutiisatiisa abalooya abalala okubagoba mu kooti basuulire Dr. Besigye n'adda mu bitale
Council Mike Kingi tubulireko ndaba babatambula babaze no babaze
kante kiyiseemu
okukosa ekyo si kibya kubanga obadde okugoberera omusango gwali twajja wano okutuuka wano bayongeramu awaayiri mulala okutukkiriza okuyingira tebatuyisizza esimu zaffe bazitulekedde bategedde nti olirooya bakusabye ID nebatukkiriza naye kati tuyingira okuyingira wano batusabye siti era tulibakwasizza nga bannamateeka abatuufu bakkirizibwa okukoza omusango era nga bakkiriziddwa bakirante baffe abalenzi so lisiti eyo tugiba waliko balooya 39 era tubalize basome omusango gwaffe tugende mu kooti naye ngekibadde ekyafayirizibwa twagireeta wano olwokutaano tugifayiringe naye alisiivinga empapula za kooti mu regisitule ya kooti ento eyaliiwo so tugikedde lwaleero kugireeta tubifayiringeyo era ebibadde bikyakira mu maaso ebituwisizaamu bwe tulowooza
mukwano gwo ate nga tubalaba mukola omulimu gwe gumu
no problem tujja kukwatula beekyokola ekinaddako naye kansubire ebiseera
twagenzeyo ne tumulabako era bamutuwadde ekitalya ali mu mbeera si nnungi naye ekyomukisa omulungi nti ali ku bujjanjabi kukomera mwana naye nga yakubwa nnyo ffe tetwategeera nti bwe bamukwata nga tuli mu kkooti ne basooka ne bamuleeta mu kagoye ka kkooti ate ne bamugjawo ne bamutwala mu kkomera lya kkooti n'abeera eyo mu kkomera eyo yakubwa nnyo 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 n'atuuka mu mbeera nga tasobola nakussa era yatunyumiriza nti basibe banne be bamutaasa ku bannamagye abaali bamukubira mu kakomera ako akekkooti eno era naye ekyomukisa omulungi agenze arespondinga ku ddagala era agenda ategeera kyetwalabye era n'atugamba tusigale nga tulwanirira
Council, about diaspora, they want the English version of what you've been talking about.
Okay, yeah. Today, this is the 13th day of January 2025. We have come back here to court, us as the lawyers of Dr. Kiza Besigye and the Hajj Obed Mutale company. The reason we have come back today is because the case was adjourned today. However, we have gone through the normal routine check procedure in this court, but today they have changed a little bit. That they have accepted us to come with our phones. The moment they realize you're a lawyer, we are told to identify yourself. Then they take all your documents that confirm that you are a lawyer. They leave you with the phones you enter. Now we have a problem that last time they instructed us to file a list confirming all the advocates and lawyers who were instructed by Dr. Kiza Besigye and the Hajj Kamali to represent them. We brought the list on Friday, and unfortunately, their registry was not open, and the person who is supposed to register all documents was not present. So we have filed today in the morning. We have filed today, but it has taken time. That's why we are late. So right now, they have told us that they have finished registering our list of all the lawyers representing them, and we are waiting for them to read our file and they call us. So we don't know so far what they are playing around, but we are waiting to be called. On the issue of my brother, Counsel Aaron Kiza. Counsel Aaron Kiza, we went there and checked on him on Friday morning in Chitalia. He's responding to medication. As you may remember, the way he was battered in court. You were there as journalists, I saw you and you saw him. So he was battered, and the way he was battered in court was no way compared to the way he was compared when he was taken outside court in a court cell. There is a court cell where they take suspects and accused persons. So while there, Aaron Kiza was beaten and battered beyond human. However, his fellow inmates who were in that cell came to his rescue. They saw the battering and it was beyond inhuman. They said this can't continue. So they stopped the soldiers who were battering him, and they stopped. So at that point, he was brought back to court, sentenced and sent to prison. Now, on Friday when we met him, we are happy to inform you that at least the prison's officers have a hospital with him and they are trying to treat him, and he's responding well to the medication. We are only praying that he properly responds and recovers properly. So today we are here to continue with the struggle for the rights of Dr. Kiza Besigye and Hajj Obed together now with Aaron Kiza. As you may remember, there were two accused persons, now there are three.
Thank you very much, Counsel.
banange abantu bali mu kugezaako okubanga bagenda kanulubali
Really, these people cannot go up.
Uyimirire wano temugenda eri. Okay. Okon Sayas.
I'm present.
Peter. I need to repeat. Okay. Tulinamkama bani. Tumusime kacho. Kintumla iko.
Council, slowly, I was doing this.
Okay. So where is the list of the parents?
sharinga
Keep standing.
Okay, now I think we
Okay. Kato Wilson. Limbas Nalukola. Juan Captain. Akachimpa Godfrey. Wanda Ronald Samuel. Ernest Kalibala. Frederick Jempanga. Ernest Azmin.
I think that's what
It is very hot. I'm a Moses. You know what, Ingrid? No, I'm so mean. No, I'm so mean.
Then I'll read you Proscopia Kunihira.
the political actors wait this first. What was good? Wait there. Wait from there. We shall let us sort out this then come back. We shall come back for you.
For us, we don't need this.
First.
political actors.
We can wait for the person to enter. We can be
If there's another room, you can come back.
Yeah, okay. Please, huh?
I'm coming to see you.
Let's take your seat, huh? Then I'm cold. It's okay.
I'm going to be able
Yeah,
to
that's
just
after. Let people first of all go back. Yeah. Then we shall handle you. Let us come for you now. We can wait here.
we don't care.
But you don't decide where to do any visit.
And you don't decide for me. I'm not a visitor, this is court. This is court.
But the court has jurisdiction. Can you help us with something? Let's have some wisdom. Politely. Kindly.
I don't want to see.
Then you can understand.
Just here. I want to stand here.
You stay here.
Hey.
Koti eba koti.
The first communication was wanted only the lawyers to first take their seats.
Yes.
Okay? Then next,
Political leaders, I know this.
yes,
So just
political leaders and
What about us parents?
yes, even parents.
We've been in many courts.
It's okay.
Parents sit first, the public sit, the lawyers come, and the chairman comes. But for you, you do it the other way around.
That's it.
If you are court, you must behave like court.
Yeah, you will end no problem. Maybe we have.
Court must be a court.
But what's important, to go to the court.
So who have the list of parents?
I'm the one of them.
And the doctor, after where the doctor?
No, what's going to happen is that we are going to allow the political leaders.
Please, whom you know?
So, and the rest, parents, those who enter, and even the public, not only the public category. So, yeah.
You took
us
the restaurant without breakfast.
Allow me to invite the political leaders.
And the aunties.
Don't do that.
Atabu ya tuhandu walingana kubanga ine linyale alina taaga ye.
We'll come after. Please. As if I said,
Yeah.
Tuli ba family.
That is our chairman Nakaseke. Yes, he's the chairman Nakaseke. He traveled from far.
I allowed it. I know you. I will allow you. Please agree with me. You say that's why I allow
That is our chairman Kawel.
That's the chairman of
I can give you the list of political leaders if you want. I can write it.
So now the other one cannot.
Enough, Dennis? Chizito Farouk?
Council enact Dennis.
Then Kabusu Moses.
The actors.
No, sakala chankala ni kwa kweli kuli mkubwa utawo honorable.
Chairman w'abavubuka.
Kama moto mugenda. Karugawa. Yambadde kooti. Sindi wa kooti.
Kooti yetu yambadde kooti ayi.
Afanda and press.
Press, we are the last people. That's how they want it.
Press.
Abainga temutambula temukyali ba political leaders
Excuse me, can I move? We are going. Who decides who? Please,
Non-food. Nabedda onasaba busabi kuyingira.
Extradition. Refunye emikono.
Well, Tom.
Ku Christmas nkunonya zakulaba nyingira munda bapadde kifuba kwetu nyambadde tisati yange wanda sadda mukula nakunoonya nani sadda yokula natula maaso bampe ekifo maaso wenyini kabisa nentuulaawo mazima sadda yokulaba watuuleyo n'osirikira ddala ate wenyini bali abamawulire bali wenyini nene we natuma omulimu wabula mukiseera wababatibu ize kyamaana kivaayo
ate n'abaana tukyali bweru twagala omusiba esente zamba
So my guys, hope you're well. Where you watching from? Political Extreme Media video. This is aka is my name. Yeah, and you're watching Extreme Media video. You're live at Court Martial in Mackenzie, where Dr. Besigye has been brought. Subscribe, like, comment and share. Hope the sound is clear. Where are you watching in from? Where are you watching in from? Where are you watching in from? Ekifaananyi kireesedde
Seka, where are you? Come here.
Okay, let's proceed. We shall kill you.
Bravo, Odazi.
President Arua, President Unu, President waffe. Tweterezeza dda President.
Abantu bano basatu baddeyo baje bulungi.
President soko itewo.
Okulembeze tabeera bwatyo. Nuulire ogambe nti ono simumanyi onokumanyi.
Bonna twaligesa.
Yali maaso soza nti mutegeera bulungi Mr. President. President ataakulonda omujjukira. President waliwo ataakulonda kulayo. Kiri tomumanyi Mr. President. Asaba ID. Ayagala si. Ate olipia
Baba Kirija linze bana.
Wait, no more clearance until I get it clear. First, we are clearing now, maybe.
Yes. He wants you katoroza wataga sigo genda yingira kana agambe kano
Say one come.
Nabakoza
Joshua Kaketo. Margaret Zalwanga.
Sabugwa utali ku list.
Abasembye nayo nze
Daje.
nakubuuze
Charles. Nduno.
katumbugulu
Katabalwa Charles. Peter Semu.
Serugo.
mbuga soma kifuula ne yoyo semu
Nze nabadde ninanyese lugonga bambuuse. Nabadde ninanyese lugonga bambuuse.
Simu kuyimirira kumanya.
Kumanya nale nanyese lugo.
Peter Serugo.
Christina batanzia ddakaawo.
Daniel Chibeti. Ronald Galiwango. Ronald Galiwango.
I'm here. I'm waiting.
Nyingire.
Swaibu Ibrahim. Jogeza Nicholas. Emmanuel Chironda. Sulaimani Sebugwao. Muhumuza Davis. Waiswa. Yengo.
And now where are we going? Honestly, where are we going to stand? Catch the work stage for Chinese.
Chicho. Chicho. That verse stand here.
Banange, we are finally on this side.
Keri akaliwa.
President, you retired.
tuyongereko ekyenge tuyongereko ekyenge waliyo space.
Guys, mweyongere first move for try to the side.
Aono waliwo omusajja wabuzi.
Anti nga weyongere your space want to be.
Anti ngamba ono omusajja wa baba wano waliwo wa BPS.
Kimanya kwagenda kufuna buli omu okubeera tofaana. Buli omu ajja kufuna obulezi.
Anti Justin mbadde namukwatidde ako.
Bebagobe ne bajjiwa. Kiganda kyange kankole
tannajja tuyongereko
Nasanga bagenda kukuba wangize mabega wange
Kati jangu leka nfunzaamu.
oyambye n'okuyamba
muwe muwali ate naye mugaya akolaganika naye alirayo Rio, ojja kuyimirira otya taata? No, space. One,
Calculator.
Somewhere. Ojira kupata chini chikuwele kumpi wanakuleta ile Alright, nange tuli mu kooti tugenda kuba tutandika kooti ejja kuba etandika
Please, Chairman, and other board members, as an organization, is my name. I appear together with Captain Andrew Kuma, Lieutenant Diffin Gaba, Second Lieutenant Regina Nazara, and I shall also be joined by Second Lieutenant Anthony Phillips Oliver. Those are the arguments for the city.
Mr. Silas Okul, Mr. Peter Lightway, Mr. Bayan Ulinamkama, Mr. Tusim Kaso, Mr. Michael Chintu, Mr. Abubakar Sekanjako, Mr. Kato Wilson, Mr. Limbazi Elias Arcola, Honorable Abdallah Chwanka, Mr. Katifa Godfrey, Mr. Wanda Gona Samuel, Mr. Frederick Panga, Mr. Katumba, Mr. Kabuye Lawrence, Mr. Sekate Julius Paul, Mr. Samuel Luis Olidwa, Mr. Chizito Farouk, Amulia, Mr. Enab Dennis, Mr. Moses Kabusu, and the other counsel who is not present is Mr. Kiza Taylor. He is still counsel for the accused. Honorable Chair, honorable members, and Honorable Chair, we have some housekeeping issues that we must deal with before we proceed. The Chair will announce. Handled by Michael. Starting off with the Senior Counsel. I apologize. I believe this is
the court. One of the housekeeping issues is regarding our right of access to the court as advocates representing the suspect in the court. And looking at regulation number 60 of Uganda People's Defense Forces Act, regulation number 1. This regulation gives you, Mr. Chairman, the duty to ensure that this court functions as any other court of law. And in any court of law, advocates are granted access to the court to be able to do their duty to represent the accused persons. Because of what transpired here last time we were here on the 10th, when Aaron Chisa was denied access and it resulted in him being jailed, we are most humbly seeking your assurances that as advocates, we are not going to endure any intimidation or obstruction as we come into court to do our duties. I must state that what transpired has caused a lot of shock. If you can see, we are lesser than we normally are. It has caused fear and intimidation among the ranks of advocates, and we thought that we needed to bring to your attention that this court needs to show and to demonstrate balance, not just the welfare of the military officers before it, but the welfare of everybody in its presence. So we are seeking assurances that we'll be able to represent our clients without intimidation. And today I must state that we have ease of access unlike other days, because we also want to be upfront. Today we have even been facilitated to sit together where we can be able to pass notes to one another. We thought we should bring that. The other issue is of officers who are manning the court not having their name tags. We are not able to know who is interacting with us, and it is necessary, because it's procedural, that any officer who is officiating at the court should be disclosed. An issue that is not, may not appear very relevant, but it is. We have noticed the changing composition of the court, that sometimes one or two members are replaced, and we are requesting when that occurs, kindly let us know who has been replaced and the names and the rank of the person representing them. You remember that at the start of the court, the names and ranks of all members of the court were read out. But at that time, these two gentlemen were not represented. So when they change, it's a bit, it throws us off balance. We are not able to know the composition of the court, which is a requirement. We have other housekeeping issues, which I'll leave my colleagues to add to. And maybe before he rises, to my colleague, professional colleague, the judge advocate, just to tell him that, yes, I'm from Kenya, but I'm East African and have an East African passport. So the unkind reference of me as a foreigner is not last time. It's not applicable. I'm an East African holding an East African passport. So apart from being licensed to practice law here, I come as of right being an East African. There is one other issue that I was required to mention before I hand over to the Lord Mayor. It's just about the terminologies. The last time, the judge advocate actually said that I could also be subjected to contempt proceedings for referring to this court as a tribunal. Whereas we are trying our best to keep saying court, I just wanted it to be on record, Mr. Chairman. The word tribunal is not derogatory at all. Tribunal refers to a court in the Oxford Dictionary, and I hope my team has come with the photocopy. It refers to a specialized court, like yourselves, which is dealing with a specific court, a specific matter. You are not dealing with general matters. For instance, a Ugandan who is a landlord cannot come and file a claim against the tenants before yourselves. You are set up for a particular purpose. That's what tribunal means. And therefore, I will plead with the judge advocate, please let us give the proper terminology, proper interpretation, because they are bound to take your interpretation if nobody objects. But if we object, then the court, led by the chairman, has a duty to see whether our objections are valid. So I would like to refer to the English dictionary and say...
Maybe for me, if I may interject, the word what is defined in the People Act, we are not going to adapt the dictionary definition. Using the UPPF Act to define what is the meaning of court. But that is the one we shall go with.
That exactly is our problem.
Which was enacted by the parliament.
It is true.
So outside that, unless you go back, and start from there.
Mr. Chairman, we seek your indulgence in listening to our objection. The English language is neither defined by the UPDF Act or even by the Constitution of Uganda. The English language is a foreign language, and meaning is found in either legal dictionaries or reputable dictionaries in the world. And therefore, the word tribunal court, which is an English language word, must be defined. And I say Article Rule 60 places a responsibility on the chairman to ensure that this court functions like other courts of law. We actually put those dictionaries every day. In the courts in Uganda, in the courts in Kenya, in courts anywhere in the world. And I invite you to check the word tribunal so that we do not undergo threats of being imprisoned for using the word tribunal. It's not derogatory. It can be used interchangeably. And what I'm really hinting at is that the interpretations of the judge advocate must be as closely as possible to reality to avoid misleading the court into acting in a manner prohibited by the Constitution of Uganda. I hand over to my colleague.
Thank you, Mr. Chairman and members. Mr. Chairman, just wanted to substantiate these issues with prayers. Number one, Mr. Chairman, issues raised by Senior Counsel are quite fundamental. The administration of justice before you over this court martial. From the list read by my friend here, Council Kalibara, the name Aaron Chiza remains on the list as one of the advocates representing the masters. Mr. Chairman, we seek your guidance on how that is going to be handled, because the instructions still stand that it should be part of the team. Despite what transpired the last time we were here, the proceedings of this one. Mr. Chairman, we're wondering whether there will be orders at the time the proceedings come. You have discretionary powers to be produced here to execute the duties, and then maybe is returned. But we need you, Mr. Chairman, to guide us on how we are going to deal with that, because it's a matter which touches on the right to get preservation, which is an integral part or a key ingredient of the right of fair hearing, ensuring Article 28 of the Constitution. And as we indicated earlier, there's a specific role that has been assigned in representing the accused persons. So we beg to be guided, Mr. Chairman, on how the Chiza is going to continue future in these proceedings as well as counsel. And we ask that you pronounce yourself on this particular matter. Again, we ask Mr. Chairman, that you pronounce yourself on the validity of the proceedings conducted when the tribunal, rather the court martial, the panel changed. When the panel, the composition changed. Because as per Regulation 26, Mr. Chairman, the sub-regulation 1, the order convening the court and the names of the officers appointed by the accused person shall be read in the hearing of the accused, who shall be given an opportunity to object to any of those officers. Indeed, at the commencement of the proceedings of J1, the names were read. But subsequent to that, as highlighted by my senior colleague here, the panels kept shifting. So, the panel that was announced on day 1 is the panel that ought to have continued. Even on the day Aaron Kiza was tried, summarily and convicted, it was a totally different panel. So, Mr. Chairman, we beg that you pronounce yourself on the validity of the proceedings that transpired after the panel had changed. And that is also fundamental in line with Regulation 26 of the regulations of this court martial. Now, on the question of intimidation of lawyers, it's a very serious one. We beg that you critically reflect. We are concerned that the whole environment is not conducive for dispensation of justice. As she has noted, and we are on record, you can see our numbers are shrinking. They are shrinking because of the intimidation. There are orders that were made earlier by you, Mr. Chairman, that all the officers manning the processes right from the point of entry should be clearly identified. They should have name tags. But we continue to have officers who are wounded, whose faces cannot even be recognized, who have no name tags. So we don't know who we are dealing with, Mr. Chairman. And this is a known practice. I can see, Mr. Chairman, members who are part of this tribunal, Mr. Chairman. Their names were announced to us. And it's not without a reason that that provision was enshrined in the rules governing the proceedings before you. Why should we continue to have officers all over, manning the courtroom here, manning the premises, handling all these the protocols here we go through? We cannot be like it. And they create the environment to be very, very inimical dispensation of justice. Very hostile, Mr. Chairman. And this is a key tenet of the due process, and it's a key tenet of the right to fair hearing, which is the bedrock of our criminal justice system in this country. Let me request that, Mr. Chairman, you make the environment conducive for administration of justice. It's a well-known principle, Mr. Chairman, that justice must not only be done, but should also be seen to be done. So it should be manifested in the proceedings, in the way all the processes are conducted, and in the way we are treated. But, Mr. Chairman, the perception, and the reality is no conducive environment. And finally, Mr. Chairman, on the nomenclature, here it is turning out to be controversial. The issue of the tribunal. I thought there wouldn't be fuss about it. Because we use these terms interchangeably, even in the courts of judicature. Mr. Chairman, it has happened even in the Supreme Court, to refer to the Supreme Court as a tribunal, to refer to the Chief Justice as an arbiter. And the Chief Justice doesn't take offense. And to refer to his office as an arbiter, or to refer to him as an arbiter, the Chief Justice does not take offense. The ordinary courts of law don't take offense, they refer to them as. Now, I'm worried if that is going to invite disciplinary proceedings, just even if it's a mere slip of tongue, and that is going to invite disciplinary action. That sends chills down our spines, and it has a chilling effect on the execution of our duties. That chilling effect is so fundamental in the dispensation of justice. If I may ask, Mr. Chairman, I have had some of the officers here addressing you as your lordship. Say, my lord, my lord. Yet, for us, we are addressing you as a chairman. Would that also be taken to be undermining this court? That we're not addressing you as my lord, that we're addressing you as a chairman? I think the judge advocate and the entire panel shouldn't take offense about this. We can interchangeably refer to you as a court, we can interchangeably refer you as a court martial or as a tribunal, because they all mean one and the same thing. But one fact remains, if we are talking about courts of judicature, that's a different matter, Mr. Chairman, because courts of judicature are well defined under the Judicature Act. And that is a different matter. So if I said this general court martial is not a court of judicature, I am stating facts within the law, under the Judicature Act, under the Constitution. That is not a court of judicature. And that is a fact. So, Mr. Chairman, I beg that you do pronounce yourself on those matters because they are fundamental on the dispensation, in regards to the dispensation of justice. I beg to move, Mr. Chairman.
My name is Samuel. Mr. Chairman, I raise on two issues. First, whereas this site will have a better conducive environment this morning, the same was extended outside. And some of us have to walk a kilometer to court. Right from the T-junction, you are faced with the blockades. I don't know why council cannot be given access to park within the premises of the court. I believe this is one of those issues that have to be taken seriously. How do I carry a box full of books from the T-junction or in the fields where we have been pushed to park? I think this should be addressed. We've seen a large parking space up here, in the premises here. So that should be handled, Mr. Chairman. Secondly, are we duly constituted as a court in the absence of reserved members of the court martial? We need to be guided on this issue too. Obliged.
Mr. Chairman, short one, very quick one. Regarding what my colleagues have said, these are being using words interchangeably in terminology. Mr. Chairman, in our Constitution, Article 151, which is at page 130, started when courts established in Uganda by the Constitution and the laws make some interpretation of judicial officer. I just want to juxtapose it with the word of the term tribunal. And it says in this chapter, unless the context otherwise requires, judicial officer means, under paragraph A, a judge or any person who presides over a court or a tribunal council and described. It is just to lay the emphasis that the application of the word tribunal or forum is not necessarily undermining court. It is just a matter of expression. And kindly request that that is borne in mind, based on the Constitution, so that it is not taken to be demeaning when we make that sort of assumption. Thank you very much.
Let me summarize this. I will start from the bottom. Council member? Yes. This was Council member said. By the time I came, I did not even see anybody in the way. So I can't tell unless I first contact people who are managing the security. But on that one I can't tell much about that because by the time I passed there was nothing. But if I'm not mistaken, I may add this with intimidation. The council was talked about. Much as you want to bring us in almost all issues, I think somehow some of you need to bring yourselves. Council Kwabo, you have been talking everywhere what you are intending to do. And I think they cannot be taken lightly. Because we need security. People who come here need security. And we don't know the tactics you want to use to destroy this court. We don't know. So you also have to check if they have been checking people who are coming. I think that's what it's all about. Because I don't know what they were asking you, what they were telling you, I can't tell. But I believe it could have emanated maybe from those statements sometimes you make. And on Council Aaron, I don't know really what you are pushing, because I've never had, unless JJ will guide us also on that one. The person who is serving the sentence to come and attend the court, that one can be advised on that. Senior counsel, I don't know if you said I don't know where this one came from. You know, of course, you are from Kenya, and Kenya is part of the East African community. So I don't know that one where it came from. But I think even in Kenya, once you serve from Kenya or Tanzania, they know. It's good you have talked about the conduct today, and you remember it was raised the other time when you said I want to talk to these people. And that's what we want. We are not here just to, it's not a war. And I don't know why you are looking at one side, you are not looking at another side. People making noise in the court.
the extent of even of standing on the chairs which are not supposed to sit where they are supposed to sit. Singing, is that a court? Or you want to make us, you want to, you are either provoking us or you are, I can't tell why you are doing that. What we need is to conduct yourselves in the manner you are supposed to conduct yourselves. This is a court. I've seen it everywhere once, the council, or anybody submitting, everybody is listening. Quietly. You finish another one. If this side finishes, another side also, so that we will proceed without any problem. I don't see where confusion comes from if we are following what we are supposed to. Unless, if you have, especially the council who have been asking about my good versus chairman, and then the result members.
Sir, I will take the opportunity to respond. There are no issues arising from the submission of lawyers, and I also refer them carefully to reference 63, which talks about the duties of the judge advocate. Reference 1 saying that the prosecutor and the accused respectively are at all times after the judge advocate is named to act at the trial, entitled to his opinion on any question of law or procedure relative to the charge of trial, whether he is in or out of court, and the accused and his lawyer. That's what it means. So any legal issues arising, I am mandated to advise this court. To begin with, holding this court a tribunal, that one will not happen. The UPDF Act defines court-martial as field court-martial, general court-martial, or court-martial court. That is what court-martial is. Even in the Constitution, it is there that you can, the DPP can have superintend over all proceedings apart from the court-martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court-martial. That is the name that is in the UPDF Act. We are not going to adapt dictionary definitions. Secondly, the issue of Aaron Chiza as one of the lawyers. I also direct you to read Article 28, Clause 3, Clause D, sometimes I never to read because when I refer to read, they say I should read, so I will read. It says every person who is, right, that's the right to a fair hearing, every person who is charged with a criminal offense shall, when you go to be permitted to appear before the quoted person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, gravity of the offense, you cannot say that when we have 30 lawyers here, Aaron Chiza, who was convicted by this court, is not there, and therefore the right to fair hearing is violated. Then what would be your role here? All the lawyers who are here, if I may ask. Or can I say you are going to say it's a constitutional violation because the person who was convicted before this court is not there, and all the over 30 lawyers are here, that the right to doctor is violated? My answer is no, and if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but to say you can be 30 and the chaser has a specific role, to me that doesn't make sense. I think I'm done with that. About the environment not being conducive, the person raising this matter deputy submitting before this court. How can you say the environment is not conducive when you are saying all what you have said? Council Pago, for me, I don't understand what you are saying. Then, the issue of court members, when we started this session, all court members, including those in the sub, were present, and all of the members before you have been following this case, have been reporting. So the fact that you are seeing one is not there, whoever is there has been here from day one when this court started. So you cannot say that these are new members, we have an instrument appointing the members. You can cross-check. They are there and they have never missed any session when we are sitting. So there is nothing that members are changing without notice. That one also has not happened. The other aspect, I think the last one, I think the one raised by Council Bank, I will not go into it because I have already given my position. But the Senior Council Karua said that me, as a brigadier at Kachungu, I called you that you were foreign. I have to ask you if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you apologize for saying I said you told your foreigner. We have interacted, but it has never come out of my mouth. That is my response.
My friend here that it is actually on video. You refer to me as a foreigner. And everybody remembers it has caused a lot of heat on social media.
No, bring it. But I never said so.
Members, we are ready to proceed. This case was which court has not pronounced itself. There's no trial at all regarding of the proceedings where the part has been shifted. That's what he was advising court. It's not that it's not he was advising who to take it. Council can make a law. This is alleging that we are changed. Can you say what's wrong?
In this council of members of this court.
I really reply. But if court pronounced itself on the matter, if you feel that you have proof that the court was not fully constituted, you have an avenue of appealing and challenging the decision of that court. But you cannot raise it here that court is going to pronounce itself. What was properly constituted, it took a decision. Now, for you who is aggrieved and saying no, then we have a controversial appeal court. Appeal with proof. They will give you an answer.
Therefore, kindly give us a list of those who sat at the sentencing session for Arunchisa, because we noticed there was a change. If you gave us that, it will help us in the appeal you have directed us to, because we definitely will take up the issue. But there is also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at, we have looked at the Uganda, Constitution of Uganda, Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this General Court Martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government, only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, interpretation of that. We also want the interpretation of the fact that lawyer, what do we mean by lawyer of choice? And by arresting and sentencing Aaron Chisa when he is in court as an advocate, and the issue was a success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. Has that interfered with the right to representation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like to refer and which we are going to draw your attention. If I may, I want to go over 2 or 3 of them and ask my colleagues to supplement. The first one I have indicated. You asked us to refer matters of interpretation to the Constitutional Court, and I am now seeking a reference to the Constitutional Court.
Madam Chairman, what I senior colleague was referring to, Madam Chairman, I think she may need to address herself on the procedure, especially on references under our rules, Constitutional Court petition for these rules. And I don't think by submitting that she's seeking a reference from this court, that's what the rules provide. It doesn't provide that. There is a procedure that is provided for under those rules. Therefore, Madam Chairman, I pray that we proceed with what the merits of the case are, instead of going against what the rules of reference provide. And maybe, sir, on the question of whatever you have raised, so I don't see how you open again. The question of jurisdiction was the first thing we relate to is when before you give a plea, the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved. As I read to you, regarding advising on legal matters, I've given my advice. So I beg you to proceed. Maybe Council was calling you, my lord, chairman. Nobody has forced you to say my lord. Even if you say honorable chairman, it's okay. But even if you say my lord, that's upon you. You cannot start challenging him that those calling you. He has not requested anybody that call me my lord. You can call him honorable chair of the court. It's okay. So I don't think even the question was asking him that can he respond. There's nothing to respond there.
Mr. Chairman, just before my senior colleagues, I again, just for consistency, we kindly request.
Council, let's not repeat what have been said and answered.
I'm not going to repeat, Mr. Chairman.
Yes.
I'm only asking that because we are amending, if we could kindly follow a process whereby if a matter is raised before the Honorable Court, we understand that the role of our colleague is to advise. So we take it that when advice is issued by the judge advocate, the matter then returns to the court to make a finding that the matter either rests or is left pending. And why we are saying so, Mr. Chairman, for example, is that there was no finality. Before I say that, otherwise, Mr. Chairman, it will appear then that if an issue is raised by counsel and the judge advocate issues advice and the court does nothing after that advice, then it means that the court is bound and subject and subordinate to the judge. Where am I raising this? Otherwise, my Lord, there appears to be a difference between counsel and the judge advocate. Regarding the issue raised in housekeeping, there has been no adverse position from the state. In the other setup where we work, when you don't refute, you accept. And it appears then that the judge advocate is either coming into the realm of the state and also taking over the court. Why am I saying so, Mr. Chairman? There was an issue regarding the composition of the panel. And we take it, Mr. Chairman, that all the honorable members of the panel are out of the decision-making process of this court. The benefit we have is that when all of them are present, it is possible to follow the events, to look at witnesses, and come to them. It would be unfair to Mr. Kalibara, for example, if he laid his evidence before me and then is cross-examined before Mr. Chiwanuka, and then the decision is made by Mr. Kwa. There is a break in the chain. So we kindly ask, before we go any further, Mr. Chair, that the issue of the panel is concluded. My neighbors whispered, and I'm sorry if they are wrong, but at the last sitting, your neighbor to my right exactly was not on the line. I don't know why any particular member here identified only her, I don't know, but they insist that she was not on the line. Other members before have said that there was one lady, now there are two. I think that causes a concern, and they go back. So it depends on the issue that if we break the consistency of the panel which constitutes the court, then the judge will advise that they are following, they may be following from somewhere, we don't see them here, but we bear in mind that the interests we are representing for their persons, that they themselves, no matter the decision of the court, must be satisfied that the process has been fair and has played in accordance with the rules. So, Mr. Chairman, if the rules say that the members should be here, then it is good that they are here. So that, and I think that's a simple matter. If they say the reserved members are here, I don't direct, but perhaps the court can get a center so that we are happy that they are there and we see them. I think that will be so right. So I request, Mr. Chair, before and maybe we first state the issue of the reference, that we put to finality the issue of the panel. Because again, if we make submissions regarding whatever I want to say, and the court has to retreat, or the state has to ask for the time to consider, and the next panel is not the same, we will then have to make the same submissions just so that the person making the decision hears us out. So I would like to Mr. Chairman.
chairman of this, I wanted to bring into his attention, actually, the labor does not have a name tag, just like the others. That was our observation. I think it's been clarified. Secondly, I think my issue of parking includes access, my access as council, access in court. I'll be on record. I'll not come back to this court if I'm parking 1 kilometer away. Access includes me parking in the premises. I think that needs to be also clarified by this court. We need a conducive environment as council for the accused persons. I'll not carry a box of books like I did today, 1 kilometer away from here, Mr. Chairman.
Sorry, my neighbor is killing me. He says they say I should insist that the person who was sitting to your right the other day, in their view, appeared to be a gentleman. They alleged it is a Lemo Kalebo, and the collar was red. So we don't know whether so we don't know whether the person there has lost the paper. But as you can see, but it's a concern that the people here in that south, when they are changing, there is a concern that maybe it may not be hard. So it's our polite request, Mr. Chairman, that the court makes a pronouncement before we go further regarding the consistency of the president. Oh, sorry, of the panel constituting the court. I'm sorry, of the panel constituting this labor court.
All right, Council. Yes, the other day there was a color here, as you have said, but as you heard from Judge Advocate, we are 19 members. Well, 7 are supposed to be here, including me, and then the reserve is supposed to be behind there also. I said, but maybe some could have misplaced by you. But it's that when the case one maybe have a problem of fees, it can go out, another one coming. That's how we try to operate. Unless you add on something, but that's how we operate. Then the accessing the court. Council, I may answer maybe from the gate here, around this premise and inside here, but outside the premise, I mean the gate, I may not have an adequate answer for that. And
I think someone can inform the lawyers that this part of the court is composed of 7 members before it can conduct business on the case of the capitulation. We have 7. There is now no case arising before this court where Major Sarah was not present. So we are in the competition side.
We need to put this in context. The spirit of the rule that requires that the name be declared at the commencement of the proceedings. The spirit is very clear. And actually it does not stop there. It requires that if there are objections to any of the members, the accused person is at liberty to say so. So if the panel keeps changing, like we have told Captain Okarebo, Kano came in just to replace the one who had been on record before without any procedure being followed. That goes to the root of the proceedings, the validity of the proceedings. That have not had the pronouncement of the court martial, the validity of the proceedings. because it was not done at that on the day. Actually, Jerome Kiza was summarily tried and convicted when Captain Kalebo Kenny, Colonel Okalebo Kenny, when Colonel Okalebo Kenny, there was no declaration made. And I've not had any pronouncement on the validity of the proceedings which were conducted in outright violation of the regulation that requires that you make a declaration that this is the colonel that is going to try you. So this is the whole point we are making, Mr. Chairman. So if Mr. Chairman will continue operating like this, then it's a negation of not only the spirit of the Act and the regulation, but the Constitution itself, which Constitution is what is establishing this very court martial. So, Mr. Chairman, we need, like, reinforcing the submission of my land friend Palm. Let the court make a pronouncement, a decision.
Counsel, the culture here is once a chosen person is brought in the docket for the first time, he is introduced to all members here and to members, which was done on that day. So this or changing of position or admiration just is whether we are proceeding. Or maybe unless you are asking that where is Ukaribo now? That's what you are asking.
Not only that, the validity of the legality of the proceedings, where a member of the panel is not introduced because Captain Colonel Okaribo was never introduced there to the person. This is the point. All the accused persons, these ones in the dock and the LBGs, because he was also put in the dock here brief. So Okaribo was never introduced to the accused person.
I think you could have forgotten, but that is the thing that is done on the first day when the accused persons or persons appear in the dock. As they are asked, they answered. They had no objection.
And when this are for Jesus, let me educate the council power. On contempt of court, you cannot say that Jesus was supposed to take a plea, you were supposed to be defended. There is nothing regulating on when you are in contempt of court. Contempt of court, you must understand about how it is the whole process works. So you cannot say that the panel was not introduced to him. Those procedures don't apply.
But I think you need to close the chapter of Chisa because he was convicted and sentenced. If you are not satisfied, you know what to do. But that one, I still
He's still on the part of the lawyer.
So should we adjourn up to finish his sentence?
It's the guidance we are seeking for Mr. Chairman. How do we deal with this?
About the convict. The one who is sentenced, who is serving the sentence.
But he still has instructions, Mr.
So which means all of you cannot proceed.
I think it is very important what the judge advocate is giving us advice to this court. And I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this court will be very important, and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are expected to side with the judge advocate, or for good reason to differ with him, because we are objecting also based on law, so that you're given the correct procedure. What happened to Errol's pastor happened, and he is going to take action accordingly. But if moving forward, the proper procedure is not applied, then we are at risk. That's what we are saying.
I think so. Mr. Chairman, close the chapter. All matters are...
No, they are closing the chapter, but what I want to tell the defense attorney is that just feel free, unless you conduct yourself in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are held responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Mr. Chairman, allow me the latitude, Mr. Chairman. On the issue, yes, much obliged, Mr. Chairman. On the issue of changing the panel, Mr. Chairman, it has far-reaching consequences. For instance, when the ruling which resulted in school sentencing my learned friend Aaron Kiza was being read, reference was made to his earlier conduct in 2024. But Colonel Okalebo was not present in 2024. However, he participated in sentencing Aaron Kiza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
So I think we need to give them the best instrument of ours so that they understand the conclusion of this court.
Whoever wants, have our questions, and they are also advocates. They are there, they are sitting, not just think they are clerks. They are also advocates. They manage our industry, it is also under the office. So you can ask anything that comes from the appointment, we have it.
Go ahead, go over to this stage.
Mr. Chairman, just the last one, the very last one, it touches me personally. It touches me. Mr. Chairman, it touches me. Mr. Chairman, I beg, Mr. Chairman, full indulgence, Mr. Chairman. This is the very last one, Mr. Chairman, which you raised in your communication, Mr. Chairman. Mr. Chairman, if I may be permitted, Mr. Chairman. Mr. Chairman, I beg for the...
I think that lawyers cannot speak at the same time.
I am seeking for the indulgence of the chairman.
He has not allowed me.
It's a rumble, I know, and
this is what we are saying now. Because if we are conduct ourselves like that, then we may not work anything.
Because, Mr. Chairman, we are dealing with matters of right.
Since we started, we are talking. Now let's hear.
Mr. Chairman, it all depends on the gravity of the matters we are dealing with. The sentence we are talking about here is dead.
Chairman,
the charges is dead.
I suggest you read or counsel for you should respect the chair and vote. Lawyers cannot speak at the same time when you are all standing. It's very unnecessary.
Council Raphael, proceed.
On the 2nd of January, this one, I believe this one had been there to amend the charge sheet. But because of some administrative matters, we could not proceed, which happened in the court. So, Chairman, court members, we want to amend the charge sheet. And we are amending this charge sheet pursuant to Regulation 66 of Uganda because the first process also procedure. It is based on the need to ensure that justice is effectively administered by holding all parties accountable. So during the course of investigations, some facts were revealed that there is a certain UPDF officer who is connected to the offense. So we intend to have the charge sheet amended by addition of that officer. And we also intend to amend the charge sheet by adding there another count of perjury. So those are the two amendments we are seeking to amend. The person who is introduced on the charge sheet is Article 743, Captain Dennis Ora. The main adult Ugandan soldier of regular forces of Uganda People's Defense Forces. And is attached to Armored Brigade.
Permission, sorry, please pardon the particulars of the sorry.
So it's an RO 74-3. Captain Dennis Ora. And we are also adding there the count of treasury, which will be count 2, including the officer and the co-accused persons. Those are the amendments we seek to have.
We object to the amendment, especially before the ruling on jurisdiction. In fact, we stopped the application for reference to await the ruling on jurisdiction. We feel that amending to add a person who is serving in the military is meant to preempt the ruling on jurisdiction. Because the court has no, it's in our view that the court has no jurisdiction on this gentleman. And we seek that the ruling precedes the amendment of the charges. When we then can raise full objection, because the charges, the amendment is not sought properly pursuant to the rules of procedure. Any colleague?
Council, which ruling are you talking about?
The ruling that you referred to, Mr. Kwame having on your jurisdiction trial. There is a ruling you've been seeking to deliver ever since we came.
From the Supreme Court?
From yourselves, from this court martial.
For several occasions that were supposed to be delivered. And that only relates to matters that were raised the first time the accused persons in a charge. That matter, I think, has something to do with jurisdiction, it has something to do with the extraterritoriality of some offences and how we put here, and therefore it's private charges. So we have all along been under the impression that this after doing. I do recall my land of criminal file once actually was and saying we are ready to proceed. But the events that have taken place since that time have not been that far. So we are keen on receiving the ruling. Mr. Chairman, that is point number one. Point number two, it relates to what the Directorate has just prayed about, the amendment of charges. I am looking at the rule that was cited in the amendment. And it talks about amending charges where there is a mistake in the name or description of the accused, or a mistake which is attributed to the clerical error or omission. And he did say that in the charge there have been reference to a serving officer. I haven't seen that reference in the charge, but I don't think that calling somebody a serving officer is a clerical error or omission, so that now we have found the name. We must have known the name, but just refused to put it there. So I'm not sure that that regulation 66 allows him what he's asking done to join. I think it was the name, Captain Davis. So I just rise on those two issues. Ruling, then try to work on that.
For the record, I'm going Besigye. I associate myself with submissions of my senior land friends. Mr. Chairman, the move by the prosecution is a calculated way of defeating the events which has already been brought to your attention through preliminary objections raised by my senior land friend, Counsel Elias Lukwago, when he objected the jurisdiction of this court. And indeed, there is a pending ruling. The other time when Senior Counsel Martha Karua came, we were not allowed to proceed with receiving the ruling, awaiting the grant of a temporary practicing certificate to Senior Counsel. Indeed, Mr. Chairman, there is a ruling pending before this court, and the prosecution is trying to. Yes, if the prosecution refers to the notes they've been taking, they realize that indeed when we compare the same with ours, there is a pending ruling, and they intend to preempt the ruling, Mr. Chairman. Don't allow them, they will be defeated. Yes.
Mr. Chair, just for recollection, you may be recalled when senior colleague Karua last year raised an application for an adjournment for an hour. God wasn't really, God graciously granted us 15 minutes. At that time, the business of the court before the adjournment was to deliver the ruling regarding matters raised by Mr. Elias. That was overtaken by events because when we came back in the afternoon, we did indicate to court that there were issues regarding instructions to receive the ruling and also the matter of Mr. Kevin. So it is correct, if I recall, that it was at my request that we are granted an adjournment of 15 minutes so that we come back and issue the ruling of the House. Perhaps Mr. Chairman, it may be necessary for court to retreat or 10 minutes just to confirm. But it is correct that there was a pending vote regarding the position of the Thank you, Mr. Chairman.
And all members. Also, Mr. Kaliwala made the resolution 66 1, but did not proceed to paragraph 2, which states at any time during the time at which there is a judgment, it appears to the court raises the respect to its idea that it is desired in the interest of justice to make any addition or omission. So that is the idea. I'm moving the court because this is doing the course of investigations. Additional evidence was brought and passing is magic, and also another count is also magic. In regard to the ruling, we are also expecting
There's a brief reviewing of Rule 66. I had read this Rule 2. My interpretation of Rule 2 suggesting that it only applies when we are at a stage where the court is close to deliberating this finding. We are still at the initial stages of this matter. So I still submit that my elected particles under this Rule 66.1 does it help him? 66.2 certainly destroys it.
Allow me, Mr. Chairman, to add just one thing.
My Lord, they have to work us.
We are relying on a matter of law to your application. Actually, the rules are so strict that once you charge an accused person, other than errors in name, and at the stage of deliberation to make a conclusion, where the evidence may have revealed a different charge, you cannot add other accused persons. That's our reading of that particular regulation, Regulation 66, 1 and 2, and we are asking you to make a finding that they cannot amend at this stage. I want to thank the prosecutor for admitting that indeed we expect a ruling from the court of the appeal.
The court is adjourned for 10 minutes.
Hezbana nyebongeza koti for some 10 minutes. After 10 minutes. After 10 minutes. After 10 minutes. The court have been adjourned after 10 minutes. After 10 minutes. After 10 minutes. After 10 minutes. And I got to the prior after 10 minutes. So and they are going to so 40. What about your Besigye after 10 minutes? What about your Besigye after 10 minutes? Adjourned after 10 minutes.
Now they want to get
Adjourned after some 10 minutes. Mwepigide wali eri mu kusooka ne bangamba waaba ogudde ku kizibu mwana omanyanya amolu oyo mwana amusobolanga okiteteeka ewayumbisi n'abamondi kali mu bulaga kankobe kunzuka waisa gwengumanyi wetolina kyotasobola kulya olya muli abaana abasinga osobola kakuli oba abaana abakola mu polisi abakola sipuli za polisi omuwala yenna akola sipuli ya polisi mpakuma mu bulamu bwange ekyo kati nze nasala bintu bibiri sokwagala mwana wange basitwago sokwagala mwana sobola aye mpaku masiki nguza ku masikali nguza eriwa 12 alukumi eriwa okwaga maso oyenda ati nina alukumi masiki tibizula ko Sirina.
Aga. Boxaga. Nari sibanga imekana kubyenda. Ngana zipapati mukora masi. Ngana wanje tegeza.
Ekasi nyoro lengira muzajja. Tundu kuzotya mu masikio mutwalo.
Box. Box ya Nasi tunamukora. Ziri wake box bakiyaga na zibuku.
Oyo musajja muna business.
Wache mfuka igera kwa campaign. Ono kwenda kusuzira ya kutambula kisikizo.
Wezwa aina busogalo yeri basinga amaanyi iwe already yeri abavamu yeri basinga amaanyi busogalo yeri kiki
kasi
aye munange nakuzina obusogalo teri mukokolo eri
kati wano omusoga wano yasigala reference yayo era kati omusogalo oyo yagulagula presence
yakira
yayireyo but all everything announcements businesses emunakusogalo neyakirani tu abakozi balabona bali prison olwono abasoga wano abalina olakusa aliyo wagunga kuloyo wamaananalo olwo omutwe bagenda yali ate kuba bawulira ku DJ Fanta lino
ate nga zena nayo timwidde
yeka nakapanti ABCD ali ku nsonga wano ate tu nsonga wano abakulembeze abagirisa emikolo gya lunaani bameeya onalebo ba MC emisi
ate neri kiki neri erimu omukono gwa kyabazinga
kati ebya business daibwe balemagana business daibwe bayawukana kati ze byabagenge tulinga maawe kati olwona abaana aboyendaabo abomiyayo abaana basobola okwiba yakusomosoboty ajakwamukala kuba owaako ngaakufunyi ate asikola abaana okwiira namwana munamawulire
nyamwaka
akitegeye okwanda oyo mulimu mulala abayitanayo
nsisobola
kintu kajja kusha
so banange ekigenda mu maaso koti eyogezeddwayo for 10 minutes era kyemanyi kyekomayo
banyumize
banange kooti ekoze etya enjala enuma mbadde siridde kyakumakya enjala ebadde enuma
abamba oli ku mirimu
enjala ebadde enuma kooti ekomyewo we are back the court is back we are back for this extreme media review. We are coming back. The court is coming back. It had been adjourned for 10 minutes. But now, the court has been adjourned for some 10 minutes, but they are now coming back. Subscribe, like, comment, and share. Don't forget subscribe. Don't forget subscribe. You're watching Extreme Media. Saying Besigye, Bakari, Robert, thank you so much for keeping it Extreme Media UK. We are in court now. Professor Nicholas, aka John Koyuki is my name. We are in court now. And all in all, what you should know is that the team of lawyers for Dr. Besigye are more than serious. This time round, it's so strict, and they had they requested for adjournment. So they are very, very, very strict. And there is a military person who will be added to Dr. Besigye and we are back. I'm back.
We are proceeding and judged to answer what we use about on the amendment of the charge.
I've had to, I would say, the application made by the state and the reply that was made by the defense lawyers. I'm also advising this court that according to section 207 of the EPDF Act, it provides that principles of civil courts be observed generally. And I read, except as otherwise expressly provided in this Act, and any regulations made thereunder, the rules of evidence and procedure to be observed in the proceedings before a unit disciplinary committee or court martial shall, as far as is practicable, be the same as those observed in the proceedings before the civil court. And the law on amendment of charges is very clear, even when you go in the criminal procedure system within the civil courts. The charge sheet can be amended at any stage as long as it does not cause injustice to an accused. And at the stage where we are still on the amending where the plea was taken. No hearing has taken place, so it is my guidance that the court should deliberate and give its ruling on whether to allow the amendment to take place or not. In the close decision, sir.
Court again. It has been adjourned for again 15 minutes. This is the second time. The court has been adjourned again for 15 minutes. Jack is they are going out. The court has been adjourned again. 15 minutes again. Don't know what's happening. You're watching the Extradition movie. Ujambo bisa mudi. So guys, the court have been adjourned again for 15 minutes. This is the second time. Subscribe, like, comment and share. You're watching Extreme Media UK. Court inaela wajiongezayo. Court inaela majiongezayo for 15 minutes. We don't know what's happening. Otherwise, subscribe, like, comment, and share. You're watching Extreme Media Yugi. Jogeza Nicholas, aka John Poyugi, is my name. Jogeza Nicholas, aka John Poyugi, is my name. We're live from Court Martial, Makindie. Uno mulundi gwa kubiri. Koti bajongezayo again. Kana kamera ekifaananyi kyekyo okujjako nga netiwaakayo, but the cameras, I'm trying to make it possible for the camera to be clear. You get? I need to buy another phone, guys. You're saying the phone TV. The camera, trying to make it possible for your camera to be there. Network has gone back to the government. What so guys, hey, I'll get it today. Anti kirabika essimu eno kirabika bw'ozoominga in ekifaananyi kifatikira. Kitegeeza mbakubire mu wide beautiful. Bwe bakomawo, should I not zoom in? I think I will leave it wide. Yeah? I'll leave it wide. Sija kudamu kuzoominga. Otherwise, you're watching Extreme Media Yugi, and Jogeza Nicholas, aka John Poyugi, is my name. The court have been adjourned again for 15 minutes. Wade wakoma wone batula for 2 minutes. Yamne bazayo. Subscribe. Yeah, I have the Angela. Thank you so much for keeping it Extreme Media Yugi. Let me go through your comments here. What do you think? What do you think on this case? I have Angela. Thank you so much for keeping it Extreme Media Yugi. Who's else there? Kaspa, thank you so much for keeping it Extreme Media Yugi. Kimenyi watu wa Gambia. Samai Kenneth, okay. Samai Kenneth, okay. You should appreciate me. Yakala yoka data, I think most of the opposition members should be here because anytime the shoes will fit them. Definitely, that's Ogwet Emma. Where are you watching in from? Yeah. Bent phone, Betty, One Manya, Jonathan. Alright, thank you so much for keeping me next media. I will not resume it again because my phone is having when you zoom in it's fun and it's fire. Zop no but watching live from Arua City. Bent phone PT from USA, Florida. Mumpa yokusente banange ndagala okusente za data. Some money. You need your contribution. Guys, this year is a little bit complicated, as you know, as you are aware. This year, but you're very many here. Why don't you like the video? You liking the video? What from the Media Beach residence in UAE, David Amanda from Florida, Ben from City, Tewalitama. Bond phone pity. Send me some money. Hey, Temumpulira. Are you not getting me, guys? I'm sure there's some. My view, I think the advocate is the one clearing, is now chairing all in that court of which Emma. All right. Thank you so much, David Command. It's 0761 210628. Yeah, you deposit, eh? MTN Airtel. MTN 0761 210628. That's MTN. Thank you. Oh, and they are far. It's a state court case. Judge John Bosco Katuchi. However, Angela is saying that it's a state court case. I want to try the Judge John Bosco Katuchi in 2005 described the same case of terrorism as stupid and amateurish and quickly set Besigye free. Younger brother. Alright guys, subscribe, like, comment and share. You're watching Extreme Media UB. You guys are Nicholas, aka John Boy, gives my name. Thanks for the great work. We're Stephen Omolo. Yeah, thank you for appreciating. Hey, but I did know my number. As the court comes back. Mansimani no mateka. Simani no mateka, mkategea. Simani as you're watching Extreme Media, you'll be subscribe, like, comment and share the link. Share to your friend, eh? Subscribe, like, comment and share the link. Should I post there? Okay, Kasfa. Alright, Kasfa, paste there my number and you put my names. I know you're watching. Yeah. Martha Karua wanange mkazi mgezi nyeuya. Kazi mgezi nyezi defeating these people. Yeah, thank you so much for keeping it Extreme Media. You can subscribe, like, comment, and share the link. I think it's almost coming back because 15 minutes are done. Guys, the number. Let me first put here the number as we wait for the court to proceed. As we wait for the court to proceed, that's the number for MTN. 0761210628. That's the number for MTN. You can deposit something, man. You know Uganda, guys. We need to buy equipment. That's the fact. And you can text me still on that number. Don't call because it's the one I'm using to stream. Don't call, but you can deposit. It's in the names of Jogeza Nicholas Jogeza. 0761210628. I will be the happiest to see your contribution. I will be the happiest. For those who are interested in change, for those who are interested in opposition, for those who are willing to see a new Uganda, you come up and show up. That's the number. So take a munango wa mutwalo gumu wa mitwalo 5 wa milioni. Nja kusanyuka nnyo ndi bobo era oliteekako ne bwotajjanga kunziika. But that's the number for MTN. It's in the names of Nicholas Jogeza. Have you got it? Comment here oba ogifunye nze njijewo. 0761210628. Alright guys, subscribe, like, comment and share. Liking, amulayiko bangi lwaki temulayikinga? Balondoya bali mu kweteesaamu bagamba ekyo ekigenda mu maaso. Guys, that's the number for MTN. Sobola okuteekako kyoteekako. Tulaba tutambuza ekintu kino bannange. Si byangu, twetaaga ka data, twetaaga transport from moving where we stay to this side. Ate nga ffe munanga abakuweereza buli kimu. Subscribing, liking, ate era commenting. Extreme Media UG. Yoliko subscribing ate mulabira ku subscribing. You are 265. Ati mwana ate liking. You like the video, guys. But at the moment the court have been adjourned for 15 minutes and I'm sure 15 minutes are almost done. So let's keep it here. Extreme Media UG. Subscribe, like, comment and share. We are live in court marking the mashup. Mu Uganda tuli mu kooti y'amagye emakindye naye munange for some contribution osobola okuteekako ku namba eyo oba osiimye. Twetaaga emikono gyammwe bannange, tubeerawo because of you people. We are one. Enamba y'essimu yeeyaawo bannange, ate okuba don't call kitegedde ekintu ekyo. Don't call. I zoom in. Tebana bakutandika. No. It has not yet started. As you can see. It has been adjourned for 15 minutes and 15 minutes are almost done. So subscribe, like, comment and share the link. You're watching Extreme Media UG. You are watching Extreme Media UG. You people, you are almost 300. Why don't you like the video? You like the video, guys. You like, and for contribution, please don't call me. You're just calling. I give you that number for a hand. For a hand, for your contribution. We need data. We need to buy gadgets actually. You understand? We need to buy data. We need live from Doha, Qatar, Tata Kalu. Mugisha Hilary is on. Tusima Josephine Wagonza is on. Yeah, Tusime, thank you for loving Extreme Media, because this is not the first time to hear your name on Extreme Media UK. Subscribe and liking that. Tell commenting. Guys, I'm not begging. I'm asking, I'm requesting. You understand? And we are Ugandans. And if you're not interested in begging, don't just shut up. Understand? Hey, I'm not. If it's not you to. If you don't want to do something, don't. It's not by force. I'm very interested. Kind of you make it. Usima expeditious. Bade ndabo bakweri. Nanyire kakate. Wama share Airtel number. Wama thank you David Commander. Wama thank you. That's the Airtel 07429 44256. David Kamande, that's the Airtel number. Thank you for appreciating. That's the Airtel number. It's in the names of Nicholas Jogeza. Nicholas Jogeza. Yeah, the court is almost coming. Organize. Hope you've got it. Hope you got the number. Okay, thank you. Thank you, man. I'm afraid of Mukisa. Thank you.
I don't belong to the police, first of all, and it's another administration. So I think then it comes to the commander, I don't know if they have them, it's what they can do. I don't have power or uniform. Uniform is given to soldiers. So say don't put on uniform which is given by the institution. It's given, it's the council there, but you don't see it. Maybe it has not been given. Listen to ruling on whether the amendment whether to amend the charge sheet or not. This court, after listening to the application by counsel, ran the counsel for the state, amended the charges against the accused person by adding another suspect, and the objections to the amendment raised by the land councils for the accused persons. The court has considered the submissions of both counsel and the relevant laws relating to the amendment of charges, has deliberated with application and pronounced itself as follows. 1. That the amendment can be made in the course of the proceedings at any stage as long as no injustice will be caused to the accused persons. 2. That the hearing of this case has not started and no injustice will be occasioned to the accused persons. 3. In the premises of this court hereby allows the application amended the charges as provided for the counsel of the state. So,
President, can you say what just?
We are going back.
The language of court is English. Each of you is going to tell court the language is going to use. I'm starting with you, Besigye. Which language?
I kindly request that we have made a copy of the charge which is amended. Because once there have been amendments which were allowed, ideally the officer preparing the charge and the court will sign, then it's a complete judgment which the hearing is complete. That is the one, then we start our questions because we do not have that option. And also, Mr. Chairman, we not be waiting because the accused person entitled advice from their counsel at that stage. We may advise them on what we see, and they say we are guilty, we say it's done. The input is that so that we know what is coming, so that they are advised before they take it. We kindly request because we haven't seen the amendment, we don't know whether it's there, and from what I can see from being alongside, I think my colleague, the court official, is reading a table, not the amended charge.
the tax will be read, but the court clerk, I think, is doing another thing in the judge.
Proceeding upon the Besigye, the language of court. court would like to know the language you are going to use during your trial.
I guess I'm still before the same court, and I have indicated that I can communicate in English.
A1, English, sir. Mafandola, which language? English. And Ra, English. Baby Tare, which language?
Yes. You are number 2.
In Amen, a soldier must follow his fellow soldier. Very correct. English. And university. And very correct. Lawyers. Known. But Captain Lola, you have the right to be with lawyers. And we have the lawyer of the army, and Captain Sobuga. It is your choice. If you have your money, you can go and pay a lawyer from outside. But Captain Sobuga and his team, they are paid by the state. So, do you want to use Attorney Suga, the lawyer of the state, or you want to hire your own lawyers?
I would intend to get other lawyers, but for the meantime, you can go with
For the moment, he hopes to use Captain Suga. Lastly, this is the panel of the judges who will hear your case. Look at them carefully. If you have any objection to any of the members, you will say so. But if they point to the reason why, I'm starting with you and the rest. If you have any objection to any of the members?
I don't know who the members are. And I don't know who they are before I raise an objection otherwise.
They are here, look at them.
Mr. Chairman, this may go to the issue of names, ranks, introducing the panel. Really, I do think that is where we are. Because you can't just say, look at them. What if you don't know someone? The requirement is actually to the names be read out and all that.
When we have been informed that the panel is beyond the ones who are seated. So we need to know who all of them are.
And then we can provide the list of the panel to your defense lawyers.
The question I've been asked is whether I object or not. I cannot object because I don't know.
I think so, you can start, you say, the chairman, and all other members. If you help yourself,
Is that what we are talking about? Brigadier General Robert Freeman Mugabe, Chair General Commercial.
Major Richard Trihanwe, I'm a member.
Captain Abdara Sajara, member. Warrant Officer 1, Mr. Robert Nyalali, member.
Major Sarah Soko, member.
Lieutenant Colonel Sam Dungura, political officer, member.
Captain Marion Akane, member.
Warrant Officer 1, Airport Department.
Captain Christina Sayuni, member.
Warrant Officer 1 for Airport Department.
Now, question is back to you. We have any objection, any of the members who have introduced themselves?
Does the court have more members than have been introduced? Because if they do, we want to know all the members of the court, whether they are here or whether they are not here, so that we can object or not object, since they are interchangeable.
That's right, Colonel. It is Colonel Okareko, who I've not seen him today. And it is Captain Nekore.
Yeah. I think, sir, on our proceedings, the key issue is that the court is composed of 7 members. We have the members reserved, they are present, and the court is duly constituted. So we'll go ahead on the next stage of responding to the questions.
Mr. Chairman, the assumption then is that the members of the panel, as duly established today, and those the 2 results, will not change because our clients are objecting or not objecting to the ones who have been introduced. The request that is made that would be a constant panel.
Exactly, that is how we do it.
Yes, yes, it will be like that.
Perfect, you are fine. Do you have any objection to any of the members and some members who have introduced themselves?
No.
Has no objection. A1, sir. Captain Nora, do you have any objection to any of the members who have introduced themselves?
No.
Captain Nora has no objection. Obeyed of Tarek. Do you have any objection to the members who have introduced themselves to you?
No.
Tarek has no objection to the panel.
The Republic of Uganda and the People's Defense Forces in the General Court Martial holding at Martin, Kampala. Criminal case number EPDF /040 of 2024. Dated today. Amended charge. Uganda versus A1 RO1274. Story Captain Dennis Ora. Male father of Uganda of sound mind for 8 years. Mr. Officer attached Plumber to the gate, person subject to the law. A2 ROV 0098, Colonel Charge Dr. Chiza West, male father of Uganda of sound mind, age 67 years, resident of Kasanga Town and Sub-County, person of the Secretary of the District, a person subject to the law. We watch of section 117, section 118, up 330. S.A. Hatch, the Secretary, male adult Ugandan of some point, age 65 years, resident of Mutunga Parish, marking the Sabagao, Sub-County, Siro County, of
certificate of person subject to this dialogue by virtue of section 117, subsection 1G, I of the EPDF Act Cap 330. And statement of offense in count 1. Offense is relating to security contract section 128, subsection 1F, the EPDF Act Cap 330. And particulars of offense. Captain Dennis Ora, Colonel retired Dr. Besigye, and had to be retired between February 2023 and November 2024, while in the cities to wit Geneva in Switzerland, Athens in Greece, Nairobi in Kenya, and in diverse places of Kampala metropolitan. In Uganda, held meetings aimed at soliciting logistical support and identifying military targets in Uganda with intent to increase the security of the defense forces. Captain Dennis Ora, have you heard and understood the charge rendition count 1?
Yes, I understand.
Do you accept or don't accept?
Madam Chairman, I seek your indulgence, seek first and not to proceed. I've just gotten instructions at the bar to represent Captain Ola. I'm only privy to the amendment now. I humbly request that I interact with him and guide him. Thereafter, I shall formalize the instructions, if you please. Just a few minutes. About 2 minutes. Much obliged. Chairman, we may now proceed.
Once again, Captain Dennis Ora, have you heard understood the charge rendition count 1?
Yes, I understand.
Do you accept or don't accept?
I don't accept.
You have not been taken. Colonel retired Dr. Besigye, have you heard and understood the charge rendition count 1?
I have heard, and I have issues with the charges which my lawyers present to you.
I think that you will address when time comes.
Mr. Chairman, we have objection to be taken, grounded on regulation 22 of the regulations of this court martial, particularly sub-regulation 1, that before pleading to the charge, the accused may offer a plea to the jurisdiction of the court before taking the plea. The accused may raise the question of jurisdiction. Such amendments on record, we have already raised issues to do with territorial jurisdiction of this honorable court. And there is a ruling which is pending before this honorable court, which is not delivered. That this honorable court has got no jurisdiction to entertain matters which are alleged to have been committed in Athens, in Switzerland, in Kenya. We have raised that issue before you, and this honorable court-martial has not pronounced himself on the matter. So it will be a violation of regulation 23 for the accused person to proceed and make a plea before the ruling is delivered.
Are you not taking us, counsel? Are you not taking us back? It is pre-taking. You can say yes or no. No. Then you can start
Mr. Chairman, the rule is before pleading to the judge, the accused may offer a plea to the jurisdiction. That is the rule. And this is what I'm quoting. And oftentimes these court martials reminded us to abide by these rules. And the judge advocate is so passionate about these regulations. I hope this time round is going to appropriate advice for this honorable court martial. That it's within the accused's right not to take a plea until the ruling is delivered from the judge.
I will remind the Council of Pablo that the accused himself mentioned that objection. I'm the one talking. No, you cannot object when I'm talking.
Can you listen and finish what he's doing?
You have not raised anything.
You have not heard what that is saying. Now you are, what are you objecting? Without even listening to what he's saying.
I can confidently tell this court and those who are present that the matter was raised and the court ruled on the matter. Registrar and avenge the ruling that was raised objecting to jurisdiction by this court. Just to remind you, you read the ruling and when it was delivered. And we proceed.
Please, hold on and you wait for the nearest legislature to read the ruling. That one will not stop you from submitting on what you want to submit, but first listen.
My Lord, with your permission, we proceed with the ruling by Public of Uganda in valid constituencies in the General Court Martial, Ordinary Makinge, criminal case number PCM 24. Uganda, represented by Prosecutor versus A1, ROB 0098, Colonel retired Dr. Kiza Leslie. A2, Kajabet Tare, accused person. Ruling on application made by Counsel Elias Kwako.
There was a ruling raised on the jurisdiction of the court. Not the one of Rupaku. The one of Rupaku is not yet ready.
We are also interested in that one. If it is ready, we have been asking for it since morning.
I think if you don't have it, either you go to Prosecution or fight.
Why are you standing for it? Get that ruling with the strike. So that we don't proceed.
kubanga kitegekanabiramu wetaalikira okusabira booti nga bayibaka nawe matuuse koteekabusi What are waiting? What are they?
Use the microphone. We are not hearing.
When the court wanted to read it, you didn't want it. Now we are on presenting the evidence the judge wanted to read it. Now the process is like. As you saw, for me, as a judge of this court, the register is even under my office. And I am reading it is here. I have not written it now. So the ruling was pronounced by court. It is that the raised it himself from day one. So it shouldn't be a point of saying that you are raising it now. What do you do?
Oh, sorry.
Should twist our time.
Kote etabuse.
My Lord, your judge is November 2024. A1, by then was Judge Kano, Dr. Kiza Besigye. He objected to all the court members.
I fail to understand. Do you think he's reading what is not written? I thought you were supposed to be orderly.
He objected to all the court panel and jurisdiction. Even A2, who is now A3, raised the same objection. J guided that the accused have to give reasons for the objection as regards court's panel and jurisdiction. A1 stated that it's a military court and I'm not a member of military. I believe I should be tried by civilian court. A2 stated the same. J guided that state had to give a reply to the objections. State replied as follows.
Ali musango imusolede.
States have admitted that the object is one, the objection is one, and the reply they stated as follows: that the neighboring law, which is section 117, applies all that is persons, that is A1 and A2, and then what were referred to. He also proceeded as state and informed court that he did not even know the lawyers that were representing the accused person. Then JA guided that court had to close for deliberation and make the ruling. Counsel Kwaku submitted that they had no opportunity to meet the accused person. To hear their story and get full instructions. He asserted that lawyers as a practice, they proceed with instructions. He proceeded to report that A1 as then was Dr. Kisa Besigye, and his colleague by then was A2.
Those are different. For me, I've always
Ulira.
The court said they are subject to military law and section 117 and 8 from the Prosecution. That was the ruling of court.
Mr. Chairman, that advocate by law is not a record. He cannot assume the role of the registrar with respect, and therefore the registrar is under your authority, but you cannot, the law does not allow you to come to court and be an advisor as well as a record.
The one who supervises the record.
Mr. Chairman, with your permission, if I may just correct my friend from the registry. When we were here last week, court adjourned the handing down of the ruling so that we could consult the accused persons, who were two at the time, regarding the instructions of counsel to receive the ruling. It might be recalled, Mr. Chairman, that when court asked or pointed out to my senior colleague, Mr. Kwaku, why there should be an adjournment, we did point out that we who were present, myself and Mr. Katumba, in the absence of Mr. Kanibara, who were counsel on the record at the time, were not in court when those objections were made. When we returned, the court adjourned to today without delivering the ruling and moved on to determine the matter of Mr. Aaron Kiza. So there was no handing down of the ruling. Now, my concern as counsel for the accused persons is that we understand that it should be the court to hand down the ruling. When the judge advocate insists that his office has the ruling, which has not been handed down by court,
Mr. Chairman, it points to the impartiality of court and any other person who follows these proceedings on TikTok and whom will only see this caption might think that it is the office of the JA which perhaps writes the rulings of the court. I think that is a grave concern which we need for the sanctity of these proceedings to remind ourselves the role of the court and our land calling the judge advocates. Otherwise, it is not little, it is of much concern, Mr. Chairman, when the registry, which should be the central collection of proceedings for the day, appears to have no ruling. The court, led by the leadership, Mr. Chairman, does not recall reading or has no ruling. And yet, the advisor of the court insists that for him he has the ruling. It is, again, Mr. Chairman, we need to remind ourselves that we, as lawyers, may understand the omissions, but to someone who is in the dock, who is a businessman, a doctor, a gallant soldier, who doesn't understand this proceedings, might think that this is a pre-arranged session. It is a little concern, and again, we wouldn't want people to be at that time. Sometimes, rather than going what we are going to, perhaps the court to retreat a little, just to put his house in order, because now we are pulling rope, and it doesn't appear quite nice, Mr. Chairman. It's my opinion.
My Lord and members, make it clear. On the first day, the accused persons were not represented, and that's when he raised the objection of Nixon. And on the same day also, Lord Mayor, as then was now his counsel, also raised objections. So there were two rulings. One was given, another one was pending. So the one that I'm reading today was giving the background of what happened in court, and then another one you have been giving us next week. So I prefer to proceed with the one on jurisdiction that was raised by accused persons at the time who were not represented. While citing section 117 of the UPTF Act Cap 330, court ruled that this honorable court has jurisdiction and has jurisdiction over the accused persons since they are all subject to trial by virtue of the same section. And it ended there. And he proceeded and read the charges that this person, to which they all pleaded not guilty. And then that's when Elias, with due respect, nobody was not counsel, had no instructions, proceeded and also raised some objections as pertaining to the charges. That's what we have.
I think I'm vindicated. Yes, because my study with the one of registrar. Why are you saying that I'm breaking the proceedings?
That one was finished. Let us proceed. I was counsel seat. I was asking the Colonel that Besigye, have you had understood the judgment June round one?
I have heard and I have responded that I have objections to taking plea on this charge and requested my lawyers present my objections.
You are right, but at this moment I'm asking you, the accused person, if you don't accept, you say not accept. If you accept,
yes. Accept what?
There are two things. If you have had understood, another question is, do you accept or you don't accept?
Accept what?
Your help to you, Mr.
Do I plead guilty or not guilty? You want me to take a plea?
he has invoked Rule 23, that he is objecting to taking plea. And therefore, it may not be fair to ask him whether he accepts when he clearly invokes Rule 23, and it allows him to do what he is doing. So maybe you could allow, on his behalf, Counsel Elias Lukwago raise the objections on his behalf as he has asked, instructed us to.
Ana Katemba ali muno.
Please, no, I'm not allowed anybody now to talk. Thank you, Mr. Chair. Because now you are taking us backwards. It is a new charge. Now what you say, just now what you are pushing for is corrected. Will he accept or he will not accept? So the issue is we are afraid of the charge. It is the accused person to plead guilty or not to plead guilty, and then you can start from there.
With your permission, thank you very much.
Mr. Chairman, my learned friend, the JA, rightly pointed to the court adopting rules of amendment of criminal charges, and also pointed out to any amendment which can be done which doesn't prejudice the accused person. That is correct, and it's on that basis that the court made a ruling regarding the amendment. My colleague will agree that once an amendment has been made, the process which was running before comes to an end and starts afresh with the new amendment. The charges we have now, clearly from looking at the amended charge dated today and the one before, are distinct. So essentially what the prosecutor has done is to start again the process which started in November. So the objections which were made there, if any, cannot be carried on by infection to the current charge sheet. To the extent that the accused person has seen and has new objections, because this is now a fresh charge sheet, Mr. Chairman, as the JA will agree with me, they are entitled to make the objections. They might be boring, they might be the same, they might be repetitive, but in a dispensation when we are saying it is his right, it is his right to make the objection. What we request is for court to listen kindly, and then also, as my learned friend has advised, and the JA, if we do it together, Regulation 23, kindly. It says, Mr. Chairman, before pleading to the charge, the accused person may offer a plea to the jurisdiction. And if he does so, the accused person may adduce evidence in support of the plea, and the prosecutor may adduce evidence in answer to that evidence, and the prosecutor may address the court in answer to the plea, and the accused may reply. Mr. Chairman, Regulation 23(1) applies before taking the plea. It is not even saying at the time, it says before. It also says that the accused person may. When it applies may, Mr. Chairman, it gives the accused person a discretion. What we understand now, Mr. Chairman and members of the court, is that the accused person has chosen to exercise their right to raise an objection. We have not listened to the objection because according to the accused person in the dock, he has asked his lawyer to make the objection. So my lord, in that regard, we would be inclined, if we are to agree that we follow this procedure of this court, we are enjoined to listen so that the state may respond, and then the court will make a pronouncement. That is what, Mr. Chairman, we understand from the clear it is before. So, Mr. Chairman, when the accused is asked whether he understands, we understand that to be part of the pre-taking process. Yet the rule requires that before that process begins, he has a right to resolution. We humbly pray, Mr. Chairman, that we abide by this regulation. We kindly request it, Mr. Chairman. Thank you, Mr. Chairman.
I also concur with the council FK. You raise your objections, let the state reply.
The humble submission of the 20 persons that this honorable court-martial has got no territorial jurisdiction to entertain the charges as spelled out on the charge sheet, and it would be violation of Article 23 and 28 of the Constitution of the Republic of Uganda if we proceeded to entertain this matter. Mr. Chairman, the Constitution confines the jurisdiction of this honorable court-martial to matters relating to offences allegedly committed within the territory of Uganda. Mr. Chairman, under Article 23, 28:12, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it prescribed by law. And also, yes, I'm coming to Article 28:7 as well. If I may be permitted to make my case, no person shall be charged with or convicted of a criminal offense which is founded on an act or commission that did not, at the time it took place, constitute a criminal offense.
Mr. Chairman, when you look at the charge sheet, the particulars allege that while in Athens and in Greece, rather in Geneva, Switzerland, and also Kenya, in Nairobi, Kenya, the accused persons are alleged to have committed those offenses, particularly the allegations that they were found in possession of weapons which are ordinarily a monopoly of defense forces. Mr. Chairman, weapons in Kenya, or military hardware in Kenya, or Athens, or in Geneva, cannot be a monopoly of UPDF. The UPDF Act specifically talks about weapons which are a monopoly of UPDF, not the defense forces or security forces of Switzerland, of Greece, or of Kenya. When you look at the provisions of Article 28(7), those acts, the impandy acts spelled out in the charge sheet, would only constitute offenses in those countries, either in Kenya, in Switzerland, or in Greece. Because, Mr. Chairman, the particulars here, they are talking Colonel Dr. Chiza Besigye, while at Riverside Apartment in Nairobi, Kenya, were found in unlawful possession of a pistol model this, which is ordinarily a monopoly of the defense forces. Mr. Chairman, this one has two limbs. One, the defense forces are not defined. Are you talking about the defense forces of Uganda, of Kenya, of Greece, or of Switzerland? They are not defined here. And that touches on two issues. One of jurisdiction, but also on regulations, particularly Regulation 22. Regulation 22 provides as follows. An accused may, before pleading to a charge, object to it on the grounds that it's not correct in law or that it's not framed in accordance with these regulations. And if he does so, the prosecutor may address the court in answer to the objection, and the accused may reply to the prosecutor's address. This is Regulation 22 of your regulations here. An accused may, before pleading to the charge, object to it on grounds that it is not correct in law and that it is not framed in accordance with these regulations. So this is a defective charge sheet. This is our contention, Mr. Chairman, that it's not framed in accordance with the UPDF, rather with the UPDF Act. It's not framed in accordance with the UPDF Act of 2005 because it is purporting to bring into the confines of this court, the jurisdiction of court, matters which relate to weapons of other countries, defense forces. It could be KDF, that is Kenya Defense Forces, or elsewhere. Because if it were a charge sheet relating to offenses under the UPDF Act, specifically they would state it here that contrary to a particular provision which talks about weapons
which are ordinarily a monopoly of the UPDF. But here they are talking to, contrary to defense forces. So if, the presumption is that this court martial has jurisdiction all over the world. That is universal jurisdiction. That whoever is found in possession of any weapon which is alleged to be a monopoly of defense forces, not UPDF, or defense forces worldwide, then this honorable court martial has not jurisdiction to deal with that. So that offense, regulation 22, and the charge sheet becomes effective. It's not correct in law. It's not framed in accordance with the UPDF Act. Then the other name of the argument, Mr. Chairman, is in relation to the way the accused persons were transferred from Kenya and brought here. Mr. Chairman, our contention is that this honorable court martial has no jurisdiction whatsoever to deal with accused persons who are not processed in accordance with the laws of Uganda or who are handled in a manner that violates international law. And I will refer you to a number of authorities which we have here. Mr. Chairman, I have the Ugandan case of Omar, Owadi, and 10 others versus the Attorney General. It's a consolidated constitutional petition number 55 and 56 of 2011. But Mr. Chairman, the difference was made to a number of decisions that have been taken by other Commonwealth countries, which we find to be persuasive. First of all, Mr. Chairman, they made a difference in the case of Regina versus Horsefeld Road Magistrates Court. It's 1994, SC, Volume 1, page 42, where the House of Lords gave a genesis to the jurisprudence relating to matters of this nature. And this is what they had to say. English common law regarding irregular apprehension of one offender abroad and the jurisdiction of English courts to try such an offender was examined by the House of Lords in that case of Regina versus Horsefeld. The earlier approach of the English courts had been that once a suspect is in lawful custody in that country and charged with an offense which that court has jurisdiction to hear, the court has no power and is not concerned to inquire into the circumstances in which he may have been brought into its jurisdiction. It was no answer to a charge that such person was arrested or kidnapped to comply with the laws of the state of refuge. That was the jurisprudence and the practice at the day. And the House of Lords had to pass that position, and this is what is had to state, which is now the common law position on issues to do with the people picked from other jurisdictions and applied elsewhere. That whatever differences there may be between the legal systems of South Africa, the United States, New Zealand, and this country, many basic principles to which they seek to give effect stem from common law roots. There is, I think, no principle more basic to any proper system of law than the maintenance of the rule of law itself. When it is shown that, and this is the principle, when it is shown that the law enforcement agents responsible for bringing a prosecution has only been able to do so by participating in violations of international law and of the laws of another state in order to secure the presence of the accused person within the territorial jurisdiction of the court, I think that respect for the rule of law demands that the court take cognizance of the circumstances to hold that the court may turn a blind eye to executive lawlessness. It would again appear to me to be a wholly inadequate response for the court to hold that the only remedy lies in civil proceedings against the individual offenders of the law enforcement agents who are concerned with the illegal actions taken. And this was also reinforced, Mr. Chairman, in the case of it was reinforced, Mr. Chairman, in the case of State versus Ibrahim. This is a South African case. The citation is there, where a court held that we also established the principles that a court has no jurisdiction. Stand up after Mr. Chairman. We also established the principle that a court has no jurisdiction to try a person who was abducted from another jurisdiction by agents of the state authority exercising power in the area of the jurisdiction of the court. And that abduction, kidnapping, represents a grave contravention of international law, the Committee of Nations, and the rule of law generally. They made reference to the aforesaid case of Regina also. We observe that courts in this country have scrupulously reaffirmed the need to observe the rule of law and prevent the abuse of the court process. The case of Dr. Besigye versus the Attorney General Supra has held that this court is obliged to intervene and even in state proceedings where the abuse of the court process is such that no fair trial can be achieved. This principle was reaffirmed by the Supreme Court in Besigye and others versus the Attorney General, Constitutional Appeal number 1 of 2006. This is the position the Constitutional Court adopted, one in Dr. Besigye's case, but also the position that has been well established in all Commonwealth countries or jurisdictions, that once the accused persons are illegally brought before court in violation of international law and they have been kidnapped and illegally extradited, then that court has no jurisdiction to deal with the same. We are making reference to the Extradition Act, a copy of which, Mr. Chairman, I'm sure you have, which clearly makes provisions on how accused individuals or citizens of a particular country, Ugandans, who are alleged to have committed an offense outside the country, are supposed to be transferred back to the country where they should be charged. One, this Extradition Act, Mr. Chairman, talks about a fugitive criminal, that one must have been a fugitive criminal to be subjected to extradition. It's abundantly clear that at no one moment has this court-martial been presented with a record that prior to their production before this court, that they were criminals, they were fugitive criminals who had pending charges that required their extradition. And even if that were to be the case, Mr. Chairman, the Extradition Act provides for the procedure on how this should be done.
which involves the judicial process, that you go through the processes of the judiciary in Kenya, where they were arrested from, present them before the law, a warrant is made, and upon a request made by the domestic minister here to the counterpart in Kenya, requesting that commence the process of extraditing that fugitive criminal who is within your territory, your jurisdiction. That is what is provided for in the Extradition Act, which we have here. This was never the case. There were no extradition proceedings in Kenya, and therefore they were not legally transferred back here. The other option would be deportation. Mr. Chairman and honorable members, if indeed they were found to have entered Kenya illegally, or if they entered Kenya illegal and committed the offences as alleged in the charge sheet, that were found in possession of firearms, which are ordinarily a monopoly of defensive forces, this could be the defense forces of Kenya. That would constitute an offense in Kenya, and they would be prosecuted in the courts of Kenya. And if the courts of Kenya deem it necessary and appropriate to have them deported to their country of origin, they will issue those court orders. That so Dr. Besigye and Obedi Butare, having committed such and such offense, you are hereby deported. There is no deportation order, there is no extradition warrant. So these accused persons were illegally brought here before you, and now the charge sheet prepared is in reference to offences allegedly committed in Kenya. The authorities we have cited here are very, very clear that you do not have jurisdiction in such cases. The one we have talked about of South Africa, it involved an illegal rendition of a particular individual from a neighboring country to South Africa. You will find it, the facts you will find them in that particular case. The case was dismissed and said this is illegal because since there was kidnapping of this particular individual from a neighboring country and brought to South Africa, they couldn't be tried in South Africa. It is the case here. Now we are being asked, Mr. Chairman, Mr. Chairman, to entertain and try a matter which did not go through those legal processes, which is a violation of international law and a violation of our Constitution, and essentially the proceedings are rooted in a nullity where you do not have jurisdiction to handle this matter. So that is our contention in this particular case, and it is the reason we are saying at this stage, under Regulation 22 and 23, Dr. Besigye and Obedi Butare are not taking a plea to charges which are penalty, charges which are duplex, charges which offend the laws of Uganda and the international law. So we pray that you be pleased to strike out the charge sheet, Mr. Chairman, and discharge the accused person. We do so.
If I may add to that, just to confirm that the extradition law of Kenya is similar to that of Uganda, that the Constitution of Kenya is similar in terms of right and the requirements of due process to the Constitution of Uganda. In both countries, due process is emphasized. And therefore, as has been ably demonstrated by Counsel Elias Kwabo, the fact that agents of the state of Uganda arrested or abducted the two gentlemen from Kenya and brought him back without any court order from Kenya. Because even where the states have an extradition treaty, you still have to present a person to the court in the country of arrest. So they ought to have been presented to a court in Nairobi, and that is the one that would have ordered for their being brought to Uganda. In that court, these two gentlemen would have had the opportunity to object to their being brought. They would have had a say. But now they were brought against their will. And the state, the authorities, have actually violated the constitutions of Kenya and laws, the constitution and laws of Uganda, and the laws of the East Africa community. The Constitutive Act, Article 6 and 7, the rule of law principle, has been violated by renditioning Dr. Besigye and Obed Lutale from Kenya. What if the arms alleged to belong to defense forces belongs to the defense forces of Kenya? Would it be a criminal offense triable in Uganda? Those are the issues. That's why in each country, jurisdiction is territorial, within the territory. I know the UPDF Act does talk of beyond its jurisdiction, but that is also a constitutional question. If you look at the Constitution of Uganda, Article 126, judicial power, Article 129, the courts of judicature. It's clear that judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of Supreme Court of Uganda, Court of Appeal of Uganda, High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Kabi's Court for marriage and divorce, and inheritance and guardianship. But I want here to agree that the UPDF courts are such subordinate courts set by law. But those courts, just like all the other, I don't know whether that is a best record. It's back. What it means, Mr. Chairman and the court, is that your territorial jurisdiction as a general court martial is limited to the territory of Uganda. And therefore, if someone is brought from another country, like they were brought from Kenya, and if offenses are said to have been committed in Kenya, in Greece, and in Switzerland, you have no jurisdiction, because the Constitution of Uganda says so. The jurisdiction of the courts in Uganda is for Uganda territory. So we are asking you to strike out these charges so that our clients do not have to plead to defective charges, and to also put weight on the submissions of areas on the fact that even if you had jurisdiction and we submit to you, the fact that they were illegally brought here, the state is not permitted in law to commit a criminal offense or to violate the law in the name of apprehending offenders. You cannot violate the law under the guise of enforcing the law. Bringing them without a court warrant, from Kenya, without extradition and a court order is a violation of the law. And therefore these charges cannot be entertained. The second schedule to the Constitution of Uganda clearly says, and it's pursuant to Article 5, it gives the boundaries of Uganda. I will not read, it's a long description of the boundaries of Uganda, but I refer you to it so that you find Nairobi is not within Uganda. And any offense committed in Nairobi is up to the authorities in Nairobi to prosecute somebody in the courts of Kenya. So you are sitting, you are being asked to take plea on a matter for which this court martial and all courts in Uganda have no jurisdiction whatsoever. If it is in Athens, the courts in Greece will have jurisdiction. If it's in Switzerland, the courts in Switzerland will have jurisdiction, not the courts in Uganda. And the UPDF Act, made pursuant to the Constitution of Uganda, cannot amend the Constitution of Uganda. So if the Constitution gives territorial jurisdiction of the courts as Uganda, the amendment of the UPDF Act, which seems to expand the jurisdiction of this court beyond Ugandan territory, is unconstitutional. It must defer to the Constitution, and these charges must be thrown out. I give way to any colleague who may have something to add.
Kino kika baganda bange kino kika.
My Lord, make before the supplement, we wait for the judge. Because he's in charge of guidance on the land because
let's wait for him.
Data aliwa neno, data is here. Sejaka. Tegerera. Sejaka. Guys, liking a video, liking a link, share. You're watching Extreme Media UP.
Submitted, we are also allowing to section 208.
Liking a video.
Those two sections appear in the face of which grant jurisdiction offenses outside grant, but contain that if that is the interpretation given by this court, those sections, then they are inconsistent with two articles of the Constitution, Article 79, powers of Parliament, which are restricted to good governance of Uganda, and then Article 129 that my colleague has read on the exercise of judicial power of Uganda. So the finding of the court, the view of the court is that those two sections do away with the objection that we are raising, we are giving advancement that we will seek interpretation of those two sections compared to Article 79. Those whether
They must be here. They can't just come through a pipe, they can't come, they have to be here for that provision. If the view is that they can be tried at a 208 or 209, as I have said, we will be moving next. Slide for 209. Thank you.
Jurisdiction, as earlier, is a greater static. And as Mr. Kaivara put it, section 208 of the paper empowers us each of these that the person alleged have committed the service offense, the teacher, left with and tried under the law, whether the alleged offense was committed in Uganda or out of Uganda. And we are saying Greece, Kenya, and Switzerland, indeed they are out of Uganda. But it is provided by the law. And it is not this court that has those powers to repeal this law. When this law was passed, I believe council could have been one of those that were in parliament, probably can boycott the paramedical sessions. But it was there, it is there. There is that, I don't know whether you read it, and it is not in this court where he can bring unconstitutionality. Yet he knows where it is supposed to be in case it is unconstitutional. Section, so that one, in regard to the jurisdiction, chairman and court members will have the jurisdiction. We also talk of defense forces. Is it the defense forces of Kenya, Switzerland, and where? The act here defines what the defense forces is. Section 2 of UPDF Act. Section 1 defines defense forces means the Uganda People's Defense Forces. So these people, the suspects are charged under the UPDF Act. Therefore, there is no question of saying, are these Kenya People's Defense Forces? Is it a monopoly for Switzerland Defense Forces? The Act is very clear. Chairman and court members, Section 117G gives powers to this court, the court martial, to try people who are not otherwise subject to military law, but become subject to military law. That is, every person not otherwise subject to military law who aids or abets a person subject to military law in the commission of the service offense. And each every person found in unlawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defense forces. And the defense forces is already defined. We also talked about how these people appeared before this Honorable Court. that it was unlawful. Unless it proves otherwise, but we believe and we are contented that these people were brought here lawfully. Other than the extradition, there are other interstate arrangements which are in place that between the two countries on border, in the border point, with terrorism and security related matters. There is a memorandum of understanding between the two countries, and it is going also. So, to do with how the accused persons arrived here, chairman and other reporting members was an interstate arrangement. So there was another question, chairman and other reporting members. That was which I believe is not there, because senior counsel was quoting in the Constitution that it limits providing but she did not quote in the particular provision. Territory. So it is not applicable in this matter. I have no partner for this.
My Lord Chairman and my members, I begin with to respond to Honorable Elias Rukwago's submission on the propriety of the charge sheet regarding regulations from the procedural regulation. Honorable Rukwago is of opinion that the charge is effective and complex, and says it does not comply with the regulation. Mr. Chairman and members, in making his case, he did not refer to which regulations the charge sheet does not comply with. Reading regulation 22 that he cited, it talks about compliance with the regulations, these regulations. And my own in the regulations, framing charges is governed by regulation 6, regulation 7, 8, and 9. And Council Rukwago has not shown how these provisions are violated by this charge sheet. Council Rukwago also says the charge sheet is duplex. Our understanding of a duplex charge is one which introduces two charges in one count, but his submission has not spelled any such in this charge sheet. So we maintain that the charge sheet is proper. Honorable Council Rukwago, together with Senior Counsel Martha Karua, talked about the production of the accused persons before this court as being illegal. However, Mr. Chairman and members, the issue of illegality is a matter that needs to be established by evidence. And that's what we shall establish if this matter comes to hearing. It is not a
matter that can be just determined at this point. And their decisions, Honorable Kwaku solidarity on the House of Lords decision on Regina versus Hospital Magistrates. On how the House of Lords departed from the common law position. Mr. Chairman and members, we respect that decision, but it applies to the law in England. It's not the position in East Africa. The position in East Africa, we have case law. We have a Tanzanian decision of Mataka versus Republic, a reported East African case. Where the East African Court of Appeal pronounced itself that once a person has been brought before the court, the issues of how he was arrested do not bar trial. It is reported in 1971 East African Law Reports at page 497. The issue regarded one of the accused persons called Mr. Chipaka, who was charged with treason. I also associate with my senior friend for the state about the position on extradition law. We maintain that extradition law is not the only mechanism dealing with transborder crime. There are other mechanisms like interstate arrangements, and they are also authorized by the East African protocols. Mr. Chairman and members, I invite my colleague to handle the submission. Lord Chairman, I do not have much to say, but I see my colleague's submissions. But Lord Chairman, we read what the senior colleague said about section 208, the EPDF Act, as far as the unlimited jurisdiction of EPDF is concerned. But also, under that section, there is something to do with service offense. The service offense is defined under the EPDF Act. Under section 1, Section 1, which service offense means an offense under this act or any other act for the time being in force committed by a subject while subject to military law. Our Chairman, that is very important, especially subject to military law. Under the charge sheet that we intend to amend, accused persons are subject to military law, specifically under section 117. Subsection person subject to military law and my law is proceeded under section 1G, but also H. And the offenses with which we are charged are provided for under the So my lord, one argument that service is not provided for extended additional cost. Lastly, my lord, Chairman, the reading of section 22, section 23, which the regulation 23, which my colleague said, I think it's something clear that before taking plea, the judge pleads the charge. The accused may offer a plea to the jurisdiction of court, and if he does so, the accused may adduce evidence in support of that. But Chairman, what we only heard from our colleagues was not evidence, because evidence is defined. And my Chairman, they never laid any evidence whatsoever that not only persuade, but also convince this court. Zero. So it's only them, information is to them, and it is argumentative that the persons are wrongly before this court. No evidence whatsoever. So my Chairman, I pray that you don't entertain such submissions, which are baseless, but also, which are not only baseless, but also not grounded in law from the section that they have read. Our Chairman, lastly, I associate myself with what my colleagues say and reiterate our submissions, that you be pleased to not allow the objection. Our Chairman is okay.
We have a briefing by Mr. Chairman. One on the issue of the applicability of the House of Lords decision or the common law position, which has since changed. I find it strange that my learned friend in charge of prosecution of this case did not take any interest in the Ugandan authority that I cited, which is Omar Awad. It's a 2011 Constitutional Court decision. I will give a copy to you, Mr. Chairman. But cited a number of Commonwealth decisions without approval. So I only mentioned a few. And specifically, it's talking about the one of Tanzania. Mr. Chairman, it's quoted out of context. It is also canvassed here, but it was distinguished in this particular decision by the Constitutional Court. And the Constitutional Court upheld, rather was persuaded by the decision in Ibrahim, or State versus Ibrahim, the South African decision of 1991. And the facts are almost on all fours with this one. If I may give you the facts briefly. The South African Court of Appeal allowed an appeal against the conviction of the appellant for treason. The appellant, a member of the military wing of the African National Congress, who had fled South Africa while under the restriction order, had been abducted from his home in Mbabane, Swaziland, by persons acting as agents of the South African state and taken back He was a member of the military wing of the African National Congress who had fled South Africa while under a restriction order and had been abducted from his home in Mbabane, Swaziland, by persons acting as agents of the South African state and taken back to South Africa, where he was handed over to police and detained in terms of the security legislation. He was subsequently charged with treason in a circuit court.
and the appellant had prior to pleading applied for an order that court lacked jurisdiction to try the case as his abduction was in breach of international law and thus unlawful. This is a precedent which is all falls with this, and the court had the occasion to say this. We note that in this instant case, the state of South Africa violated the territorial integrity of Swaziland by sending its own police to abduct the appellant from Swaziland. The South African Court of Appeal also considered that it had no jurisdiction to try him, given the breaches of international law that South Africa had been privy to. Therefore, they said, therefore, the other Tanzanian case which is cited here is distinguishable from this one. So I invite this General Court Martial to treat that as a redundant submission because it has no basis in the law. And the decision that was made final, that particular matter, is what I read earlier, that court has no jurisdiction to try a person who was abducted from another jurisdiction by agents of the state authority exercising power in the area of jurisdiction of the court. That puts this matter to rest, and this is a court, this is a constitutional court whose decision is binding on this General Court Martial. Then regarding the definition of the defense forces, and the incurably defective charge sheet, because we maintain it's incurably defective. When you state in the particulars that the pistol and ammunition found in possession of Colonel Dr. Besigye and Obedi at Riverside apartment in Kenya, which is a monopoly of defense forces, Mr. Chairman, it will be stretching the UPDF law to levels of absurdity to state that a weapon found in Kenya is a monopoly of UPDF. That would be absurd. That a pistol found in Kenya is a monopoly of UPDF. That would be an absurdity. This is the defectiveness that we are talking about in the charge sheet. It cannot be. And it would only be a monopoly of UPDF. And even here locally, by the way, Mr. Chairman, there are authorities to the effect that a pistol is not a monopoly. But those are matters that can be handled at a later stage. It's not a monopoly of the UPDF, a pistol and ammunition. Now, on the question of an MOU, it sounds strange. Wouldn't be a submission coming from lawyers who went to the law school and they are here dealing with matters of this nature, brave as they are? Because, Mr. Chairman, we are talking about matters of life and death. And we are talking about an MOU to override a written law. When you look at this act, the Extradition Act, which commenced on the 28th of July 1964, in the long title, Mr. Chairman, it's very, very clear. An act to provide for the extradition of persons accused or convicted of crimes committed within the jurisdiction of other countries. This is an act. An act, this is the long title, an act providing for the extradition of persons accused or convicted of crimes committed within the jurisdiction of other countries. This was not made in vain. This is the only framework we have under the law that can be invoked to have an accused person transferred from Kenya to Uganda. There's no other framework, legal framework. I wish they cited the law under which that MOU was executed. At least even laying it on table that this is the MOU. And the law which provides for elaborate mechanisms you have to go through before you get one transferred back to Uganda. And you are saying that one can be Jackson.
by a mere piece of paper called an MOU. Mr. Chairman, that should be treated with the contempt it deserves. On my side, the final submission, Mr. Chairman, the issue of Article 2 or Section 200, 8 and 9. It's no Section 208 of the UPDF Act. Mr. Chairman, this law, this particular provision, was not meant to operate in isolation of other legislations. No. It had to operate first and foremost within the existing constitutional order, because the Constitution is supreme. My learned friend here, senior counsel, and my brother Kalipara here, they have cited the relevant provisions of the Constitution which are compelling, which take precedence over any legislation. But even then, the UPDF Act comes into play after you have complied with all these other requirements, with all these other laws, the extradition law, the Constitution, and all this. So that's when it comes into play. But if you cannot cling on one particular provision and say, it gives us universal jurisdiction over all matters worldwide. So the other argument that we have to know, we have not particularized the defects in the charges are equally neither here nor there. Because, Mr. Chairman, we clearly indicated that the charge sheet, the way it is structured, when you look at it on the face of it, you can see the defects, the charge sheet itself. Because, yes, my learned friends have cited section 6, 7, and 8, which talk about the particulars of the charge sheet. Exactly this is the point we are raising in this amended charge sheet here, where they are stating that the county 4, county 3, and 4 together with actually county 5, where they are talking about rounds of ammunition and the pistol. Here we reiterate our earlier submission. We are saying this particular, these particular counts do not spell out exactly the acts, the impending acts of the committed by the accused persons in regards to the defensive forces here in Uganda. This is the point we are making. The impending acts in regards to the defensive forces here in Uganda. Let me say it differently. If indeed they wanted this section 2.8 and 2.9 to come into play, they should have expressly stated that they were found in possession with the firearm, with the pistol and the ammunition, which are a property of the government of Uganda. If that's what they had said, that would be a different case. That which are a property, subject to proof of course, which are a property of the UPDF. That would be their case. But it cannot be sufficient to say that whoever is found in Kenya with a pistol and ammunition, he offends the UPDF Act. There are so many people in Kenya right now with pistols and rounds of ammunition. Would they want to suggest that those are all subject to martial law here in Uganda? This is the absurdity we are talking about in this charge, that it's not particularized, and it is duplicate in nature, that it purports to bring all these issues of ammunition, of the pistol and whatnot, all lumped together to make it as if it's one count which is put here.
So basically, on the question of evidence, as I wind up, Mr. Chairman and honorable members, that we should have laid evidence before you regarding the way they were transferred here. Mr. Chairman, the charge sheet speaks for itself. The record is very clear before you that all they are complaining about, all the issues they are raising, Kenya, Switzerland, and elsewhere. There is no single impande act here that offends the law which they are put in the particular of the charge sheet. Nothing. So all they are talking about are acts which are ready, which have been committed in Kenya. And in this particular case, Mr. Chairman, and in this particular case, Mr. Chairman, we want you to find that these acts complained of here can only be, first of all, processed by those respective jurisdictions, Kenya, Switzerland, or Greece, but not to be directly brought here before you. I ask my colleagues if there are other specific issues that want to cover. I thank you, Mr. Chairman.
Yes, that's good. With your permission. The prosecutor says that the prosecutor explains how the accused are voting. I don't think so. It is once the defense raises an issue on how the accused were brought, it's up to the prosecutor to then rebut by showing the court that they were brought here with it. If there is an MOU, let it be laid on the table. I have cited the extradition law of Kenya. It's Cap 75 and it is online. Anybody who is being extradited, even if they are willing, they have to go before a court so that an order is issued. So if they have an order, let them show it. If they have an MOU, let's look at it and see whether they fulfill the order. We've also cited Article 129 of the Constitution of Uganda, which limits the territorial jurisdiction of all courts. The courts of judicature and courts meet at an act of parliament, and that's where this court matter falls. There is no other statute that can be greater than the Constitution. So the Constitution limits you to Uganda. Therefore, kindly discharge this duty. And let us all go.
Mr. Chairman, if you allow me the latitude, the prosecution has miserably failed to defend the charge sheet. Mr. Chairman, that indeed, although the rendition was illegal and unconstitutional, there are other mechanisms through which they can have the suspects brought in Uganda. Incidentally, Mr. Chairman, the prosecution has conceded that indeed, actually it is an admission that indeed the state committed illegalities and constitutionality while bringing back the two accused persons, Dr. Besigye and Adjournment, back to Uganda. Mr. Chairman, I implore you and your entire court, the entire panel, that find it not difficult while striking out the charge sheet, throwing out all the allegations, Mr. Chairman. Mr. Chairman, set our clients free. There is nothing to prove. The prosecution has miserably failed and has conceded, has admitted. I thank you. I beg to submit.
Oh, Mr. Chairman, I thank you. Mr. Chairman, I thank you. Anak. Anak, microphone. Guys, we are still waiting.
Now, even if there was an extradition treaty, which it is not for me to say, it's for the state to say, that treaty cannot be made in violation of the law. I have cited the Extradition Act of Kenya, Cap 75, and it forbids extradition other than in the manner in that act. A person has to be taken before the magistrate, even when they consent, because some people consent to being extradited. There has to be a court order. And I have also cited Article 6 and 7 of the East Africa Community Constitutive Act, which I say have been violated because they oblige member countries to follow the rule of law principle. When you violate laws of Kenya, the Constitution of Kenya on due process in Article 50, the Constitution of Uganda, the laws of Uganda, and even immigration laws, because at the border, their documents were not stamped. We are saying they have come before this court pursuant to illegal acts by agents of the state.
All right, guys, liking the video, subscribe.
That's not for me. You cannot cross-examine me. I do not, it is not for me. May I draw the attention of the court? I have no duty whatsoever to bring any extradition treaty. He who alleges, according to the evidence, must prove. I have not talked about an extradition treaty. It is Mr. Prosecutor. I am not going to do your work. Produce the extradition treaty before the court. Produce the MOU before the court. Do not try to get labor from me. Free labor from me.
Hello. Nah, subscribing, liking, commenting. When you subscribe, that's how Extreme Media you get. You know, pull up Extreme Media. You're watching Extreme Media you get. Me, Jogeza Nicholas, aka John Paul. You're very many here. Why don't you like the video? You're over. Subscribe. Guys, subscribe. Guys, chili confirmed. Akomao tomorrow. Chili confirmed. Akomao mcha tomorrow. Tomorrow. Aba sisa camping unga bola ba. They have tomorrow. Cancel. Tomorrow.
Dr. adjourned to 25 for the deliberation on the matters raised in the proceedings.
Ate oli wokusatu bamwerabidde guys. Okay, subscribing, liking, atera commenting. Oli kulaba Extreme Media UG. Koti esazeewo nkya tomorrow 14th naye nga mwebalina okubanga mugo tugoberedde abatusuubiza ku buyambi. Guys, kindly do it. Katufuna no interview from these people. We are going to get interviews from Balodin here. Alright. Subscribe live. Subscribe. Liking, commenting, subscribing. Don't forget to subscribe. If it's for first time here, you're watching Extreme Media UB, and there is hope of Besigye to be released. Alright, subscribe. We are still in court. Share. I think there is some happiness tomorrow. I think it's confirmed tomorrow. Tomorrow. We are still here. We are still live. We are still live.
Are we coming back tomorrow?
Yeah, tomorrow.
25th was for what?
He didn't mention 25th. Alright. Sharing. Enkyalo bakomawo mu kooti wano sivaawo. Talking football. Guys, subscribe, and when you subscribe, you click in the notification bell so that you'll be updated on whatever we upload. You understand? You're watching Extreme Media UB. Also, thank you for your service. Okay, great. Those who promised me some little money as contribution, I think we need to buy. Extreme Media should get gadgets. We need gadgets. Kindly do. We send your Uganda is confused. Share. Free my uncle. Thanks. Who's this one? Who thanks? Numbers of Shamim. Thanks. First time. Yeah. You're watching Extreme Media UG. Subscribe, like, comment, and share. Let's Bakomao Ncha. For those who don't understand, Dr. Besigye is coming back tomorrow. Okay, Mkonyezi Cherry. Kindly. Yeah. Bakomao Ncha. They are coming back tomorrow. Share. Subscribing. Don't forget to subscribe. Don't forget to subscribing. And when you subscribe, you click in the notification bell. So that. Okay, Kimonge. Okay, together we can. Thanks, bro, for the coverage. Thanks to Frank. Thank you so much for keeping it. Yeah, we are live on Extreme Media UG. I know there are some people ababa links baberayo naye you're live wherever you're watching in from. When you're using this link to mukulabira Extreme Media UG. Yeah, Isaac Okonyokelo, thank you so much for keeping it Extreme Media UG. Yeah, big up Extreme Media guys. Thank you so much for also tuning in, keeping it Extreme Media UG. Usima, thank you so much for keeping it. Thank you, Isaac. Yeah, guys, just subscribe. Subscribing. Chris Mugezi, thank you. Godi, thank you too. Yeah, don't forget to subscribe if it's your first time here. Yeah, don't forget to subscribe. If it's your first time here, subscribe. Thanks, man. Richard, thank you. Wherever Angel, thanks, Jeff. Thank you so much. Yeah, thank you so much. It's hard. I want to have but thank you so much. Jogeza Nicholas, aka John Paul Yugi, is my name. Is my name. And those who promised me some kumacha esawa satu tugenda okubanga tuli waneeno era mulilepo bulinzi okategedde akantu ako. Yeah. So tugenda kubanga tufuna abantu nga boogeramu naffe batubuulire bajja tubuulira amayiga.
Senior counsel is going to address you.
Okay. Yes, that's one would like to know. Why are you raising the advise client to take
Kale kwata. Kwatiramu.
Following the arrest and sentencing of Aaron Tisa on the 10th for merely trying to get access to the court to represent the client. We feel as advocates intimidated, and we raise those issues before the court. I believe we were not satisfactorily answered, but the other issues we have raised, because we had to draw the attention of the court. We are not here by accident. The law provides, the Constitution, the UPDF Act, all provide for an accused person being represented by a lawyer of their choice. And therefore, we need access to the court without let or hindrance. Today, access was much better than earlier, but outside the court, most of the lawyers are having to walk long distances, being forced to park their cars away from the court. We raised that as an issue. We are yet to receive a satisfactory answer. Then it came to the issue of amendment of the charge sheet, which we were rejecting because we wanted the issue of jurisdiction dealt with first. They read, the court ruled that the charge sheet, they will allow the amended charge sheet. It was read. An accused person who is a serving military officer was joined in the charge. He pleaded not guilty. We advised our clients not to plead because they had objections. But they are also well versed enough to know that when they have issues, they should not plead. So Dr. Besigye spoke and said he wanted his lawyers to raise objection to the charges. We have raised objection to the charges, mainly on the manner in which they were brought from Kenya without any extradition order, without appearing before the court, without immigration procedures. We have also raised the issue of territorial jurisdiction. The Constitution of Uganda and the UPDF Act all point to territorial jurisdiction within Uganda. The UPDF Act appears to give jurisdiction outside, but we are arguing that jurisdiction is territorial because that's what the Constitution says. We are now waiting for a ruling tomorrow. The court has adjourned. The military has also, the prosecutor has given his replies. We are waiting for a ruling tomorrow on whether the courts in Uganda, including the court, General Court Martial, has jurisdiction on matters that happened in Kenya, in Athens, Greece, and also in Switzerland.
What can you say on the issue of Section 117, which talks about civilians being charged in this code? Because it is what they are raising, and Article 208.
We have raised, and it's for the court to rule, that there is nothing in the Constitution that confers upon the UPDF civil or criminal jurisdiction on Ugandans, and that their jurisdiction, especially civilians, their jurisdiction is limited to disciplinary offenses of military officers. Those are the issues the court will have to rule on tomorrow.
With the adding of the new assault on the charge sheet, what is your take on that? Because even before the accused is taking plea, they are adding one another suspect. What can you say on that?
Let them hear.
The new charge.
We objected to it and were overruled.
Well, it has taken us by surprise because, you know, this is a person who is coming from nowhere. His particulars are not clearly spelled out. And when they allege that the offenses have been committed in Switzerland, committed in Greece, committed in Kenya, nowhere are they mentioning that they did it together with Dr. Besigye. So how they came up with a joinder of a charge sheet, I mean, joinder of the parties, it's something which is really baffling to us. You know, you can only join individuals who are alleged to have been committed to crimes together. So if there is a chain, I mean, the series of events involving those individuals, then you can join them in one charge sheet. Now, all along they have been talking about Dr. Besigye and Brady Rutale, who were found at Riverside. They never mentioned this third party, this soldier here whom they have brought here. They never mentioned him anywhere. So all of a sudden, they come up with an ambush and bring up this gentleman and add him on the charge sheet. So of course they are up to mischief. These are all choreographed things intended to cause a mischief, as I've said. But we are also prepared to deal with the same. One thing I needed to emphasize on the question of extraterritorial jurisdiction, you see, they have attempted to bring a very old case from Tanzania. Let me tell you, for us, we have done enough research on this matter. The Commonwealth position is that you cannot abduct an individual and try them elsewhere. It's not possible, it's not allowed in law. It's good we have submitted to them a number of authorities from South Africa, how some actors in ANC had been abducted from Swaziland. We have submitted to them authorities from the House of Lords of England and a couple of other jurisdictions. So the position is very, very clear. It can only be through extradition. You cannot abduct an individual whom you have not even considered to be a criminal fugitive, a fugitive, and then you subject them to martial law. That is totally out of, outside the Constitution and also the practice within Commonwealth.
Counsel, after being overruled by the court on the issue of counsel and keys and the clients are still behind the bars, what can you say over that? Because they say that someone who is convicted cannot represent anyone in court. What is your take on that? Is it all?
No, unfortunately, there is no decision, and we have issues with that. Because it's only the judge advocate who gave his opinion. And you know, under the law, he's only an advisor. His opinion, he says, it's like any other opinion. It is like an assessor, actually. It can't amount to a ruling. So, we are baffled by this practice here, where you find a judge advocate whose duty in law is just to give advice, but when he makes a decision, and he actually is proud of it, that his opinion is binding, is final. And he even had the audacity of telling us, whoever is not satisfied, you are free to seek for a reference. That shouldn't have come from him. that whoever is dissatisfied, he can take can seek reference to the Constitutional Court to interpret the opinion of a judge advocate. We can't even do that. That we are going to the Constitutional Court to seek for the interpretation of it can be of the court, fine, but the opinion of the judge advocate, which opinion he renders to the court martial. So we take exception to that, and there are issues we are going to handle that legally. Definitely, we are not going to take that lying down.
And Aaron Chiza is not sleeping on his rights. We know he'll be taking action. Watch the space.
Ensonga muzirabye olwaleero tubadde n'ensonga ezisoosewo eza okulaba nti balooya batiisibwatiisibwa okuva lwe baakwata Aaron Chiza ne bamusingisa emisango egya contempt of court ne bamutwala ne bamusiba myezi 9 nga kimenya mateeka kubanga ennaku ezoogerebwako ziba 30 ate n'embeera ekyali mu kooti wano nga bwogiraba bwefaanana okulaba nti balooya bagamba ku paakinga eri wala mujje nga mutambula n'ebitabo byammwe mujje nga mukola kino okutiisibwatiisibwa. Mulabye chairman wa kooti yennyini atuuse n'okugamba nti gwe Lukwago oli omu ku abo abagenda batiisatiisa kooti eno era tujja bakangavvula. Njagadde omubuuza nti ogenda tukangavvula mu nkangavvula ki asirisi aŋŋaanya okwogera nsitusaawo nga njagala mubuuza mpulidde ng'ogamba nti tweweze nnyo okusuula kooti eno nti era ogenda kutukolako. Njagadde omubuuza nti mu nkolako efaanana etya tugitegeere egende ku rekodi, naye ekintu ekyo n'atulemesa okiddamu. So embeera ekyagenda maaso ey'okwagala okututiisatiisa naye tetugenda kukkiriza kutiisibwatiisibwa. Yagambye ye talina buyinza kubali ebweru eno n'abo ab'amagye abatalina namba abeekapisa ebintu ebitategereka maaso abeekapisa balinga bagenda ku mwezi n'ebintu ebifaanana. So tujja kusigala nga tubavumu okulwanyisa ebikolwa ebyo. Naye n'ekirala kyekyokuba nti baleeseeko omujaasi omuntu omulala mu mbeera etategeerekeka. Ebbanga lyonna tubadde wano nga boogera ku Obedi Lutale, Dr. Besigye babasanga ku Riverside n'amasasi n'emmundu episto nti Athens simanya Dr. Besigye yali alamuza kino ayagala bayambeka jalumba eggwanga compromising security nebyo byali simanya ne suite zirambi teboogerangako nti waliyo omujaasi gwe yali nayo nti yaliko naye mu meeting kale oba yali naye lwaki ye tebamusitulirako ne bamuleeterako kwoli. Kakati balina emipango gye baleeta. Waliwo ekkobaana ery'amaanyi eriri awo era eggwanga lirijja okutegeera mu maaso awo ebintu bijja byerambulula bulungi. Kati ekirala ekisembayo kyekyokuba nti kya jurisdiction ya kooti eno obuyinza bwa kooti eno okuwozesa emisango gye bagamba nti gyajjizibwa bweru wa Uganda. Ekyo kwegamba n'atali leader akiraba nti kooti eya Uganda wano eya General Court Martial ebeera etya n'obuyinza obugamba nti gwe twakusanga n'ekissi oba pisto n'amasasi Riverside e Kenya kye bayita monopole ya UPDF nti pisto esangiddwa ne Dr. Besigye nga bwe bagamba e Kenya munayo monopole ya UPDF. Kigamba ekyo n'atali looyo okiraba ne bagamba nti kyekyo kyekibawo obuyinza okumuwozesa. Ekyokubiri kwe kidnap tubalaze amateeka nga bwe gali. Si Uganda yokka yeesooseeyo, ensi nnyingi South Africa eyo abantu ba ANC bagezangako bawamba mu nsi gye baddukiranga, naye kooti etaputa ssemateeka eya South Africa n'ekirambika bulungi mu misango mingi ng'eraga nti abantu abo abawambibwanga kuva Swaziland kuva luddawa ne baleetebwa batwayingirwe South Africa kyalinga kimenya mateeka era ng'emisango egyo egisazaamu. Ekyo nga kiva ku misango n'Ebungereza gye twajja amateeka gano aga Commonwealth nayo yagamba nti nedda omuntu yenna gwe bagamba nti bamusanze mu nsi ndala ne batayita mateeka matuufu omuntu oyo bayina aba bamuleese mu bukyamu. Kaakati e Uganda tulina etteeka lya 1964 Extradition Act lye lirimu enkola mw'oyita okuzza omuntu yenna gw'ogamba nti alina emisango e Uganda. kitujja enviiri ku mutwe bano gaga nti Uganda erina endagaano. Waliwo endagaano eyakolebwa wakati wa Uganda ne Kenya. Bw'obeera e Kenya ne balowooza nti oli muzzi wa misango e Uganda, balina engeri ey'ekimpukumpuku gye basobola okuyisaamu ne bakukomyawo. Nti era ekyo tekirina, tubabuuzizza endagaano eyo yakolebwa mu tteeka ki nga Matama Ntengo, nsonyiwa okozesa ekigambo ekinene. Ye endagaano eyo eriwa nga bonna tewali anyega. Kakati katulinde kibagenda okusalawo. Ddala bagambe nti Uganda erina endagaano emenya Extradition Act, nti tulina endagaano ne Kenya egamba nti osobola okukidnappinga omuntu e Kenya n'omukomyawo wano nga tayise na mu immigration, tayise mu mateeka gonna. Tulinze tulabe ddala oba General Court Martial egenda kugamba ekintu ekyo nti kiri mu mateeka okubeera n'endagaano ne okuwamba omuntu n'omuleeta, ate nga n'endagaano eyo yennyini gye boogerako yakolebwa ddi, ani yagissaako omukono, byonna tebabyogera. Extradition Act eyo eri bulungi nnyo. Etteeka eryo eri extradition ligamba nti bw'aba ali Kenya, minisita weeno yasaba era alina kuba criminal fugitive ng'ali eri minisita oweri naye n'agamba nti okay, kale katubitwale mu court, magistrate court nefulumya court order egamba nti oyo mumuzeeyo e Uganda. Kiri mu girasi nti ebyo byonna tebyakolebwa. Kaakati court tugirinze tulabe kyeneesalawo olunaku olw'enkya. Byebino byennyini bye tugamba nti obuyinza obwakoogerebwako ako tekali waggulu wa ssemateeka. Bagenda mu kawaayiro 2008 ne 2009 kusooka 2008 ke basinga okwesibako nti kakkiriza UPDF court martial okozesa emisango singa wonna gy'ogizza wonna mu nsi yonna. Ssemateeka kirambika bulungi nti judicial power oba obuyinza obuwozesa butandikira buva mu bannayuganda. Bannayuganda tebawangako genda court martial kufuuka kooti ya nsi yonna, tebagiwangako buyinza obwo nti yefudde kati General Court Martial yagala kwefuula ICC nti kakati ICC ekwata ku misango gy'ensi yonna. So akawaayiro kali redundant era ne bwekanaba nga tekali redundant kalimu kugamba nti kale osobola okuba nga ozizza emisango naye ng'oli munnayuganda n'obeera eyo n'omenya amateeka g'e Uganda. Ne tuyinza gamba nti pistol n'amasasi byosanze ku Riverside ng'ate tugambye nti bya UPDF ng'olwazizza emisango against UPDF Act. Tebakugambye nti pistol eyo Dr. Besigye yagenda naye okuva e Uganda. Bw'aba yagifunira Kenya nga kale nga bagaddala bamusanga nayo nga yagifunira Kenya, aba amenya amateeka ga Kenya tamenye ge Uganda. So n'olw'ensonga eyo akakawaayiro 28 kaba tekakola.
Ensonga ya Aaron Kanso mukoze mutya mukomeza okubanga
Aaron nsonga nkulu nnyo era tusuubira nti ensonga zonna bannamateeka abamu ffenna tugenda nazo mu maaso. Ye muvumu gy'ali yadde akyalumizibwa naye nga tugenda mu maaso n'okulwana okulaba nti tagenda kumalako myezi egyo 9 ng'ali eyo. Tubagala obbakakasa tugenda kukola kyonna ekisoboka okulaba nga tabeera eyo myezi 9 kuvundira eyo mu kkomera. Twamulambuddeko akyali muvumu naye era nga akyazi ekirala kyonna ffe kyetusimbako essira nti akyali ku lisiti y'abannamateeka baki ba Dr. Besigye. So tubagambye batubuulire naye Judge Advocate ye yeefudde omulamuzi. Ensonga eyo nkulu nti Judge Advocate mu mateeka alina kuwabula kooti ey'amagye so si kuwa biragiro naye kati awa biragiro. Ekyo ensonga tugenda girwanisa nnyo nnyo.
Ngaba president of opposition bonna aba Democratic Party UPCFDC bwenna bajje tuyimire ne Dr. Kamukinza
so banange kyemulina okumanya if you've not been following us and you've just joined in, Besigye will be brought tomorrow back here. Yeah, it is tomorrow. Thank you so much for keeping it Extreme Media UD. Abooluganda omukulu Dr. Kizza Besigye ne munne bakomezebwawo nkya bakomezebwawo nkya. So anange subscribing, liking, commenting, and when you subscribe making sure that you click in the notification bell. You need a notification bell so that you're very updated on whatever we upload. You understand? I have about to see this. Can't take your number, guys. Can't take your number. About to gamble. Or to go to data. Yes, number yeyo ananga wade atuyambeko obuyambi wano tufune ku sente za data uye ncha tukomawo Evans Media kyakabi naye eyo namba eri mumanya gange Nicholas Jogeza 0761210628 msolo tekako ku deposit eri mumanya gange Nicholas Jogeza yeyo namba eri mumanya gange Nicholas Jogeza naye nga ebyokweti nabyo bibadde gulugulu waneeno kyolina okutegeera boys masiki eriwa tujye wale nfune change
Zina change.
ndidde ng'olina change ayo tujye wale nfune change Esther Momo, thank you so much. Interview Chigwa, ina interview. All right. Because mandela ifunga swinga uyira nchali kuvula olaba tutoke tuogere
Wade ndoza interfering.
No, it is okay. Kati pola mpola. Ndagala mpanise ku timu eri. Timu y'omulodi. Ngira amanyi gwe. Media gya biduka. Muyo gyabe.
Kolaborera hivi. Gundi cherichi.
This is Extreme Media Yugi.
Extreme Media.
Extreme Media Yugi.
No na namba yangu.
Gwe nakuteredeko ne message. WhatsApp. Yenza kuweza nti okujja kubeerayo mu kooti. Yenze.
Akusavinga nga chronicle.
Nicholas.
Nicholas, yes. I have it as Nicholas.
Ati era nayo gye tuli. So guys, ebyokulinda bibadde. Kale, guys. Afande tumye bannange oba aliwa. Guys, ebyokulinda byo bibadde gulugulu nga boolaba. Ebyokulinda byo bibadde gulugulu. Chachigayi, obadde babweru? Mbadde ngamba toyingidde. Guys, subscribing, liking, atera commenting. If it's your first time here, no boda tutambule. Afande. Katuddemu encha. Ebyokwerinda byo bibadde gulugulu kyamulina okumanya kiri makinge. Boda. Guys, and nekirala emufunye namba. Alright, subscribing, liking, boda. Boda, anotebakola kiki? Njagala boda naye maama. Nange nguleyo kamotoka mutusondere banange mutufunireyo. Extreme Media tufuneyo ku byentambula. Tutwe okukabira ki? Okulina boda bino. Bimenya. So guys, eno tuli makindye. Bwobanga tulina ku subscribing, liking, atera commenting. Njagala kukola tukole. Ngenda kisasi. Manye kisasi. Meka. Ngenda kuwa kakaaga kuba kenzijidde. Nzijire kakaaga. Omusajja gwe toyagala akola sente. Tukole, jangu tugende. All right, bannange tugende. Tambula. Afandi. Guys, kamalamu katugende mulabe deployment nga weeri eno mu maaso eno. Deployment ebadde y'amaanyi. Musajja teeka mu speed. Nabola ba deployment bweto bwe badaba. Amaje babadde bangi mukategedde akantu ako. Amaje gabadde mangi wano road block ndowooza olaba. Road block mundinzi jawa muteekeko sente. Oyo namba gye mbawadde. Yeah. So that is it. I think I should say can I say bye bye to you people? Wakati tugenda kuba tutambula. Mwebale kubanga mulaba Extreme Media Yugi. Akalango okatunda otya text me on that number. Ofunye number eyo. Text me on that number, guys. Text me. Abuza akalango textingao. Textinga kunamba eri awo oba genda ku profile yange kuliko namba yange ya MTN yeri ku WhatsApp. On this profile yeri ku WhatsApp. Ngo textinge then tusigale nga tuogezaganya. Tujategeera ebintu byakalango biri bitya naye ng'ekyatukomawo still ekyatukomawo tetumanyi oba ayinza okuba nga ateebwa. Kitegedde ekintu ekyo ayinza okuteebwa enkya, you never know. But subscribinga oba nga tonaba kusubscribinga, likinga video ate era commentinga awo abyagala okutegeera ebyakalango, namba yeeyo gyentaddewo, namba eri okwo kwira oba ntextinga ku WhatsApp. Tulabe nga tutandika tukola mpola tukole naawe nkole naawe okole business tugitambuze. Naye nga kiri confirmed obanga wakajoininga Dr. Besigye ne munne bakomawo nkya and okusinziira ku balooya bwe bapulida be batukonfaminze bakakasiza nti ayinza okuteebwa. Balina essuubi nti ayinza okukola ki okuteebwa. So tujja kuba nga tukutuusaako buli kimu. Ayagala okunkonako, ayagala kulanga naffe, okwagala kukola ki. Remember we didn't specialize, tuba tukola politics yeka, tukola buli kimu. Kintu ekiba ekikoze amawulire kyonna tukikola, tukikwasaganya kyonna ne tukituusaako. Sijja kujjako live eno paka nga ntuuse. So obanga toli mu Kampala ojja kulabako ne Uganda sawa ne weri mu kufaana mose mu kibuga Kampala. Tuyitidde saidi za Nsambya. Eno Nsambya Road obanga ogimanyi eno gye tuyitidde. So thank you so much for keeping it Extreme Media UG. Subscribing, liking, ate era commenting awo. Ekigambo subscription kya muwendo nnyo. Tuyitidde saidi z'eno Ensambya mugenda kulaba ne mulabe Uganda bwefaanana kati. But kitegeezeddwa nti omukulu Dr. Besigye ne munne bakomawo nkya. Ate gwe naawe obitegeera kazaaba ennaku zikyukamu mpola mpola. Kamu tukansa Katanga Road. Peter Barunga, what are you saying? Tuyitidde saidi za Nsambya. Tuyitidde saidi z'eno Ensambya. Eyo nga simanyiyo. Naye ng'oli mu Kampala, this is Nsambya. Wano Nsambya This is Nsambya. They were in Nsambya, you understand? But it's confirmed it's tomorrow. Dr. Besigye. Thanks for giving us the amount of Besigye. Okay. So Buga, nobody will see ma. Confirmed Dr. Besigye ne munne bakomawo nkya. They are coming back in court. They will be brought in court. Court martial enkya kooti y'amagye era kyesobola okugamba kiri kimu nti amazima go bapulida banyi bapulida baki babana ababiri amazima bataddewo embeera bagitaddewo sijja kubalimba bataddewo embeera to the extent tibachallenginze n'oludda abawawaba okategedde. Asante Victor kale webale kusiima. Alright, so this is Nsambya.
and this is the Zambia hospital. Ojukira alien skin of woman yaja attacking but doctors. It's this place, it's this hospital. Waneno erigolaba alien skin we yagira chi na attacking. This is Zambia hospital. Alien skin we yakuba our civil gang. Yeah, that is the Zambia hospital. Just come to Katonga Road. That's where everyone is heading to. Peter. Oh, are you sure, Peter? Oh, Bambi, God will do for you. Okay. Katonga Road, really? I'm not sure. I'm not sure about agenda kujeyo. So sinaba kitegeera. Ogamba kwe offices za PFF. Naye nga obanga tona subscribinga likinga. Tugende mu maaso subscribinga. But it's confirmed. Have an jam Uganda limu jam. Or if you're not in Uganda, go take a mangu. Wow. So, kyemulina okumanya ekintu kyo omusango bagulinga abagulinya ku mfete. You understand? Balinga abagulinya ku mfete. Watuli kwale na moro oba mujimanyi. Thanks bro for update. All right, Adjournment. It's okay. Waliwo abagezaako okubanga bakanga nga balowooza nti oba they intimidate me kuba nti mumbaweereza kutegeera balowooza ffe tuli ba bulijjo bagamba akasimu basobola okanzijako nze nga ndi Kibanda. Besigye bamuleeta nkya kooti. Tomorrow, Dr. Besigye bamuleeta mu kooti lunaku olw'enkya. All right, thank you Kisacha Kateja. Yeah, you're watching Extreme Media, you guys. I'm subscribing, I'm liking, I'm commenting. If you don't everything making news. You didn't specialize into what we call politics or entertainment. This is a company with the professional people. Tetukola kintu kimu kyokka naye banange jamu ali mu Uganda. You understand? Njagala embuzi efuula engezi ejje ejinyaga esimu ngobere wano enkolire. Yeah guys, it's too much just jam y'omungi naye nga amazima gali nti tuli mu kugenda tuyinza oyitirawo Katonga awo tulabe oba nga tutuuka tulaba balodi meya bano. Nange kyemanyi enkya I have a feeling, I have a sense nti amazima enkya Dr. Besigye ne munne bayinza okubanga bateebwa enkya. Yeah, so subscribe na like mbatera commenting. Bitide side zeno ku nga ku Jinja Road yegendo oyitira. Nga ku Jinja Road. How are the proceedings? Proceeding, Dr. Besigye and a friend will be brought back tomorrow. So tomorrow Dr. Besigye will be brought. Tomorrow enkya Dr. Besigye babakomyawo mu kooti enkya era saawa 3. So mumugibeereko kuno Extreme Media yugi njakuba just kubanga tonaba kusubscribinga saawa zino ziyini okitegeera subscribinga likinga ate era commentinga era kusooka kubanga mbata tulabe Let's meet again in another episode. Jogeza Nicholas aka John Paul Yugi is my name, and this is Extreme Media Yugi. Mbagala nyo bali kubanga mwekumide ku Extreme Media Yugi. Mwebalire ddala mu subscribing oba tonaba ku subscribing ate wo mbo wanzo ku subscribing okirikinga mu notification bell so that you'll be updated ku buli kimu kye tukutuusaako. Mwebale nnyo, mwebalire ddala.